exclusion. The first intervention will be done by Dr. Marina Rosa, who will talk about the margin of appreciation doctrine recreating colonial patterns towards migrants, the evolution of the ECHR's decisions. Um, Dr. Marina um, um, Dr. Marina is a faculty member at the School of International Relations and at the College of Law and coordinator of the Migrant Clinic of the Ritter dos Reis University Center in Brazil. Please start. صباح الخير للجميع. اسمي مارينا من البرازيل.
And waiting to organize the important conference. Well, this paper is inspired not from the international law of the international relations, but for the Gabriel Garcia Marquez when we questions in the Cien Años de Soledad why it's the negligence to use the Latin Americans to think of just social justice with the same originality that allowed in literature. However, the theoretical fundament of these studies is the decolonial perspective and the TWAIL, the third world approach to international law. Well, international law was understood a priori as mechanism for maintaining colonial tradition. The internationalist commitment is born thus aimed at legitimizing the colonial expansion, the state sovereignty, and the subjection and domination of the other people, the origin peoples in America. In this sense, international law is instituted to guarantee the European ultramarine domination because of the unique and necessary juridical language to establish relations between Europe and America. That is, international law fills a juridical language gap which permitted the subjugation and domination of the people what would be colonized. According to this order of the ideas, Francisco de Vitoria is the precursor of international law when he proposed the juridical harmonization. Under this consideration, international law uses the ruling language of human rights beings to justify the conquer of the new territories and expropriation to build a juridic mark to settle the European jurisdiction of America. International law is restrained in the first moment to the dissemination of liberal and individual values to the domination of economic rationality of the different things and being. There was no intention to reverse the colonial power structure neither the hierarchical human beings discourse nor the difference between North and South. These assumptions are resurfacing by the advent of the Peace of Westphalia. The conclusion is not of the insufficiency of the Westphalia model put in check the capability of the international law to regulate the relations between states. From out is observed a change of position for the internationalists when we started to recognize the individual as an international law subject, while the human rights brought to via of international sign. For what for part of the international law doctrine, the Universal Declaration constitutes the legacy over which are expressed the universal and indivisibility of human rights. The Declaration follows the French model. This is a hegemonical fundament of human rights, which base is not which her basis is found at Illuminism and attaches the consensus of rights to individuals' rationality adjusted to the colonial patterns. The maintenance of the colonial universal intended text would provide the continuation of prejudicial and excluding practice, making possible to suggest the human rights are universal from the perspective of the modern culture, but are not universal for ones looking for the outside. This condition would contribute to the settling of European universalism, forming the patterns already ambition as universal global values, which among them would be human rights speech. That is, it's not about talking from the declaration relevance, its relevance to the institutions of human rights, such ICCPR. It's, if not the clarify, the interesting in international law because its colonial and imperialist past and present to recognize that the modern international law selectiveness where has roots in European heritage are universal. And under this background, her emerged emerged different judicial authorities of permanent characters in the supranational plan, aiming the concretization of the international justice, like the European system of human rights. But it should be noted that it is apparent in the Universal Declaration. Additionally, the creation of European system was inserted in the big European cooperation contest to consolidate during the Cold War, strengthen their economies, and above, establish a counterpoint to the Soviet regime, preaching that human rights and democracy are assured at and by Occident capitalism. The European Convention constitutes in regression of compared the Universal Declaration, because only 10 years after the institution of the Convention is when the European system recognized economical, social, and cultural rights, and only in 40 years after recognized the right to equality and non-discrimination. It is not refuted that the system innovating institutes independent legal organism in the international plan to judge violations of human rights in Europe, like the European Court of Human Rights. The European Court has been contribution to the protection of human rights in Europe later because of recognizing or recognition of its procedure capability to the individuals or the vast firm jurisprudence. However, the acting of the court has been limited of the margin in the application of the margin of appreciation doctrine, which gives to the states a maneuver space to exercise its functions, what allows that they take actions to interpretation and protection the consecrate, which allows them to adopt the measure deemed appropriate to interpretation and to protection the rights enshrined in the European Convention, since they would be in a better position to define the content and limits of those rights. That is, in name of the national security, the Court of Human Rights and the European states converted the right to migrate and to state prerogative, reaffirming the colonial charter of the international law, because in the name of sovereignty, the European state expel refugees, in the majority the citizens from the ex-European colonials, violating the principle of the non-refoulement, relative rights, etc. But when you compare it to the Inter-American Court of Human Rights, we observe that in this court, the non-refoulement is a jus caution principle, as defined in the advisory opinion about the work migrants and in the case of family Pacheco Tineo versus Bolivia. But in Europe, that is not admitted. For example, in the Delaya versus France, a Roman citizen whose name had been listed on the Direction Générale de la Sécurité Stratégique by France, and he was unable to conduct his business or provide or receive service in any of the Schengen area states. In the Sala versus Netherlands, the court permit, according to the margin of appreciation, the expulsion of refugees would face a real risk that socio-economical, and humanitarian conditions in the states to return the Somalia. Also, the court in N versus the UK concerned the removal of an HIV-positive applicant to Uganda, where her lifespan has likely to be reduced because of the treatment facilities that were inferior to those available in United Kingdom. But in the South and Elmi versus United Kingdom, the European Court finally had that the indiscrimination violation in Somalia was of sufficient level and intensity to pose a risk to life of person of any civilian there. That situation of general violence in Mogadishu was sufficiently intense to enable the European Court to conclude that any return would be at a risk of ill treatment contrary to Article 3, solely on account of his or her presence in the country. Well, my argument essentially is until and Sufi and Elmi versus United Kingdom, the European states certainly has the power to decide who can enter and state or in their territory, but this decision is the start to alteration the colonial position of the European Court of Human Rights to guarantee authority and emancipation for the migrants is that their human rights prevail before the security and state sovereignty. Start because that criteria may be still along the manipulation of the language of the human rights by the European states. Thank you very much.
ثانك يو. شكرا مارينا للالتزام كمان بالوقت. وشكرا على ورقتك وورقتك اعتقد انها تظهر
This subject, your paper. Thank you for covering this subject. It is for sure that there is misuse of human rights to control. So we will now move to the second lecture, Engendering Constitutions as a Way to Protect Women's Rights. Sana Asarghali will speak. She is from An-Najah University. She is a faculty member of An-Najah National University. Yes, good morning. It could be that the subject that I will talk about today is over discussed. However, when we talk today about gender sensitive constitutions, we see that there is an importance to speak about all the rights of all segments of society. However, today we will focus more on gender. We will talk about gender sensitive constitutions. We will also ask why it is so important to talk about it and how to implement such a constitution. When we talk about this subject, one of the main things that we remember is something that happened in 2010 with Ruth Ginsburg in the Supreme Court of the United States of America. She had a debate with Sandra O'Connor, who was the first female judge who was appointed in 1981. Ginsburg asked, why not have 9 women in the Supreme Court? And the audience started laughing then. That question was bigger than that. The question is, why is there always 9 men judges and they bring 1 or 2 female judges? Why is it considered that women, why do they always marginalize women and just add them for the sake of adding 1 or 2 women on a side, that is, as if irrelevant? Unfortunately, despite what some people say, we still see this happening. Even in the Palestinian Constitutional Court, there is a very, very limited number of women, and it seems like they look at women as if they're not good enough. So this constitution does not just talk about women's rights, but it talks about justice between genders. So this is a constitution that should give equal opportunities regardless of one's gender. Therefore, when we talk about the importance of such a constitution, we are first of all talking only about the basics, and also the presence of a gender sensitive constitution means that we are having a democratic constitution that includes all parties. Today, almost every constitution starts with the constitution is ours, or we the people. Therefore, this means that there should be an effective participation and engagement. For example, in Tunisia, they included women, disabled persons, and many other segments of the society. That's why when we write the constitution and we say we the people, we must include all segments of the people. Therefore, we must always aim to, for example, in Palestine, we aim to receive recognition from the world. However, if we become gender sensitive, then that would mean that we are becoming part of the world more and more, engaging. For example, CEDAW and all the discussions, um, gender sensitive constitution is very important because how can one join CEDAW, Convention for the Elimination of discrimination against women? So we must reformulate our constitutions in different countries in order to become more gender sensitive. Uh, and many times, negative things lead to gender violations. For example, if the legal text or stipulation does not mention women or the equal rights of women, that would, in a way, support the violations against women. Another thing is that when we talk about gender sensitive constitutions, we usually talk about countries during conflict and after conflict, in which lots of gender issues occur. In Palestine, we have a kind of transition towards democracy and statehood together. And this is a very difficult thing, by the way. And in order to ensure that this uh, binary transition would take place, there should be a full representation of all segments of the people. We see sometimes some informal uh, speeches taking place. For example, in Belfast, women played a very prominent role in uniting between Protestants and Catholics, but when the official negotiations took place, they totally excluded women, even though the women were the ones who were behind unifying or having a treaty between Catholics and Protestants in Belfast. So there is the marginalization of women. In other words, today, if we look at the Palestinian Basic Law and even the draft constitution of 2016, do you know about the low rates of female representation? You will be surprised. These were all hidden doors, and there was no sufficient female representation. Therefore, in order to overcome such a thing, we should use certain mechanisms to overcome. In order to avoid prolonging my time specified time period, I have something here to present to you. It seems like okay, yeah. Why include the gender sensitive? I will show you something here. The language of constitution. The language of the constitution. Many people do not know about that language. Um, some people misunderstand that, but the constitution drafting is very important. For I'll give you an example. I don't know if you remember the story of an Egyptian citizen lady, that is, who wanted to get citizenship for her children. They told her, how can you get citizenship for your children if you're not married to an Egyptian man? So it seems like citizenship was as if a male dominated thing. Therefore, the constitutions have tackled this. For example, the Reed versus Reed case in the United States tackled this. Two people were married, and one of them wanted to be in charge of the property. So they explained that the law, or so they kind of claimed that the man should be the owner and not the woman after they got divorced. But the court tackled this correctly by saying how can you abuse the legal stipulation and provision. Therefore, for example, in Tunisia, we see the law saying Tunisian men and women, and not just Tunisian men or just Tunisian in the middle implicitly. So even uh, in the Quran, it says the believing women and men, or men and women. So al-mu'minin wal-mu'minat, which means believers who are men and women. So even the Quran took this into consideration, males and females. So it is very important to write the constitutions in the best way. For example, in our Palestinian context, we see that the PLO is the sole representative of the Palestinian people, and the PA is in charge of the constitution. We sometimes disregard this or don't see this. Therefore, we should see more of muwatanin wa muwatinat, which means male and female citizens. The law must always be gender sensitive. For example, South Africa, after when they wrote their constitution, they said male or female president. That was just a reminder for the law, because if in the law, because if a female person runs for elections, people shouldn't be surprised. They need to know very well from the law that gender sensitivity is always there. Therefore, these gender sensitive constitutions are very important. So, for example, if we see the 2015 report of the UN, it seems like their next report will be in 2018 or 2019. In the UN report of 2016 or 15, we see they mention the importance of women's participation. It seems that in the majority of times they assign women in non-key positions. 15% of the heads of courts in the world are women. This is a very low number, only 15% of court judges. So if therefore the making of the constitution also needs practice on the ground. Unfortunately, in the vast majority of Arab countries, unlike Tunisia, which was playing a leading role in 2014 in theory, but where is the practice? It seems like they only write beautiful things, like after As-Sibsi in 2016 in Tunisia, who said that Tunisian women can marry anyone they want, even from a different religion. The Tunisian people started countering that or standing up against that. So it's very important to implement things on the ground, not just keep saying the beautiful things, but also to implement that on the ground. Therefore, yeah, I don't want to prolong because Mrs. Reem and Butman will talk about Sharia courts. So why not have the freedom to choose to marry whoever they want? So in practice, another thing, shouldn't the constitutions like the hashtag equal payment thing, shouldn't the constitution support the equal payment of men and women? So shouldn't the constitution specify? So the making of constitutions and the practice of that, it's not only the issue of the equal payment, but it seems that the equal payment for work of the same value, this is the main concept. So the work that is done with the same value by men and women should have equal payment. For example, if a man and a woman are running a house, men and women should have an equal share in the things. In Kenya's constitution, we see that they introduced many female parliamentarians. However, unfortunately, during the Kenyan elections, the people did not elect women, but at least the Kenyan constitution supported the presence of an equal representation by women. So, as I said, it's very important to implement things on the ground. When we talk about practice, we don't only talk about women's rights, but we also mean the all segments of the society. That is, the first implementation is the right of people to the courts to reach or access courts. For example, in Palestine, we individuals have the right to resort to courts, but this is not really activated. Has not been really activated. For example, if I get harassed in my work and one of my constitutional rights is abused or violated, where should I resort to? Shouldn't I resort to the constitutional courts? Therefore, there should be the activation of the direct resorting to the courts. Another thing is something we talked about yesterday: the state of emergency and the states of exception. Legal exceptions have led to many violations and abuse of people's rights. The state of emergency is highly problematic. That's why the states of emergency must be specifically defined in order to avoid the violation of human rights. And we see that under states of emergency, there is the restriction and violation of human rights. Another important thing for implementation that we must focus on is the independence of the judiciary. Some people might say this is not the time to talk about this, but no, it is very important. When I talk about all of these, I talk about them theoretically, but a constitutional drafting committee must come and write that and must make sure to implement that by other parties. So when we talk about a new orientation for Palestine, I think that before drafting the gender sensitive constitution, we must start by fixing the mechanisms of the judiciary and the people's freedom to resort to courts and to get rid of the legislative vacuum that we're living in Palestine. And that's because when I write a constitution, I must have a budget for the legislations. For example, when the law comes and says, so let's put it this way: the law has several problems. I'm not talking about religion. I'm talking about the whole law, modern law. In the vast majority of Arab countries, we see a confusion. Uh, so they do not understand the civil um, aspects of the state. Great confusion is in Arab countries in even understanding the constitution. The constitution seems to be not fair or unfair to many segments of the society. I think that I have covered my part. So thanks so much and God bless.
Thank you, Sana. It seems that even in drafting, when there is a text which is applicable or not, we should ponder more. I mean, it is only for self-interest that we live. There are, I mean, consequences and relative points. The third intervention is Mr. Ralph Wild, who is a professor in the London University College dealing with international, and he will speak what is beyond the drafting of history, beyond the state sovereignty paradigm between different active elements while exercising authority in certain situations. So the floor.
Shukran. It's a great privilege to be back here in Palestine and at Birzeit. I'm very grateful indeed to Mudar for including me in this event, which I'm learning at which I'm learning a great deal. I also want to pay tribute to Joyce for such supremely efficient and comprehensive organizational assistance and generous, warm hospitality, and to the wonderful translators who have done such an outstandingly accurate work and assistance here, and also to the very helpful and welcoming student volunteers. Thank you very much. Now, on Monday, a group of us attending the earlier conference were taken to meet with the community of Khan al-Ammar. At that meeting, the community leader, Amran Nashak, said, and I'm paraphrasing, "People often think that what we want is to improve the humanitarian situation here, for example, proper access to water. No, what we want is to be able to return to the place from where we were displaced." When I heard this, I took it to mean that, whereas of course he was concerned about humanitarian conditions and improving them, he was more concerned about the situation itself, the denial of his right and that of his community to return to the place from which they were displaced. He didn't want the Israeli colonial project to be made more humane. He wanted it to end. Now, the Universal Declaration of Human Rights was, of course, adopted as part of the broader post-1945 lawmaking efforts on humanitarian issues, which included a year later the 1949 Geneva Conventions. And those conventions, of course, include key rules on occupation law, supplementing the Hague regulations in a move more generally in this field of law, commonly described as a shift from the state-centric bombs and bullets law of armed conflict paradigm to a human-centered, humanizing approach. Hence the shift in the name being given to this area of law, International Humanitarian Law, IHL. This claim of humanitarianism, embedded in the very name given to the law, is then associated with occupation law in particular. So the ICRC legal department, for example, asserts, and I quote, "The law of occupation is primarily motivated by humanitarian conditions." Now, I'm told that a predominant, if not exclusive, focus on IHL can often be seen when legal questions and advocacy strategies relating to Palestine are discussed. In particular, I'm told there's such a focus, especially on the part of internationals here, whether foreign states, international organizations, or NGOs. For example, the Swedish NGO Diakonia, which in its general work claims to be concerned with ending, and I quote, "poverty and oppression," when it comes to Palestine, has a focus described as being on Israel and Palestine, open brackets OPT, i.e. only about the occupation, and within this through an exclusive IHL lens via its IHL Resource Center. Now, as Hassan Jabareen pointed out at the previous conference, an exclusive focus on the occupation and IHL, when this is understood as synonymous with occupation law, or IHL insofar as it applies to the occupation, excludes crucial elements of the struggle: the Nakba, the position of Palestinians in the land of Palestine beyond the West Bank and Gaza, and the refugees. Thus, the exclusive occupation and IHL focus frames the struggle in a way that doesn't even acknowledge the existence of these aspects of the struggle. What is claimed to be a humanitarian effort to vindicate the needs of Palestinians in the West Bank and Gaza is also a means of erasing the struggle as it relates to all other Palestinians, both on the other side of the Green Line and beyond, and also the Palestinians here and in Gaza, as far as their own links, including of land and property, on the other side of the Green Line are concerned. So put differently, the exclusive focus on the occupation IHL framework denies the right of return, the right of Palestinians on the other side of the Green Line to equal treatment, and more fundamentally, the very notion of the Green Line as necessarily an organizing principle for the question of the status of the land of Palestine. In my presentation at the other conference, I argued that also, even within the distorted focus exclusively on the occupation, the exclusive IHL occupation law approach is of necessity, because of the limitations of this area of law, only concerned with the humanitarian conditions of the occupation. The occupation itself is not placed into question. So much then for IHL. As I mentioned, the humanitarian paradigm shift in the laws of war with the Geneva Conventions can be seen as part of the broader foundation of modern international human rights law with the adoption of the Universal Declaration. And that declaration was, as has been mentioned, part of the so-called International Bill of Rights, including the two main global human rights covenants, followed by an array of instruments dealing with the rights of particular groups, different types of rights, etc. Palestine's decision to accede to most of these human rights treaties 4 years ago has, of course, been part of a strategy alongside ratification of the Rome Statute and instruments like the Diplomatic Relations Convention to enable recourse to the international mechanisms of enforcement associated with these treaties, such as the International Criminal Court, and with the very recent case brought against the US regarding the Jerusalem embassy to the International Court of Justice. In the case of human rights treaties, this has enabled Palestine to bring a case against Israel before the Committee on the Elimination of Racial Discrimination. Now, apart from the Rome Statute and the ICC, what these treaties and their enforcement mechanisms have in common is that they are state-centric as far as the obligation bearers involved are concerned. To use them to complain about Israel, then, as in the racial discrimination case, is, unlike the referral to the ICC, to affirm and accept Israel's statehood. This, then, potentially has implications for the position of Israel as it's currently constituted, both in terms of its territory, its identity as a Jewish state, its population, and the rights of people, including Palestinians, under what is being accepted by this process to be its territorial jurisdiction, and the question of the right of refugees to return to the land covered by this territorial jurisdiction. These are, of course, broader issues relating to the recognition of Israel in general. My point is that they are also implicated in the use of international human rights law as a tool of resistance against Israel. This use also has a particular impact on the dialectic between Palestine's position on Israel's statehood and Israel's position on Palestine's statehood. Off the bat, in triggering any given mechanism, as in the complaint to the Racial Discrimination Committee, Palestine is assuming and affirming Israeli statehood. But Palestine can't activate the mechanism unless it is in turn a state in international law, something which Israel disputes. Indeed, I understand that Israel is planning to put the denial of Palestinian statehood at the heart of its objections to the jurisdiction of the Racial Discrimination Committee in that complaint. This will therefore require Palestine, unlike Israel, to have to prove its very existential legitimacy in order for the case to go ahead. The question of Palestinian statehood will be determined by the procedure in a humiliatingly unequal dialectic. Palestine must affirm Israel's statehood, but has to prove its own. Israel gains a further affirmation of its statehood and an opportunity to further delegitimize Palestine. So what is supposed to be a mechanism to determine individual rights also requires a further deepening of the process of Palestinian recognition of the State of Israel, while at the same time having to go through a formal process whereby its own existential legitimacy is subjected to a sustained trolling exercise by Israel. Of course, the very state whose actions are largely responsible for the conditions that place the practical viability of the state of Palestine, and so its conformity to the international law test for statehood, into question. All the more humiliating because this necessarily operates in tandem with a requirement that Palestine reaffirm its recognition of Israel. If the outcome of this process is that the Racial Discrimination Committee concludes that Palestine is a state for the purposes of the convention, and so its jurisdiction, that might be seen as a positive achievement in vindicating Palestinian statehood more generally. But it still involves a process that treats the issue as one to be determined by weighing up the arguments of Palestine and Israel on the question of Palestinian statehood, as if Israel has and should have a particular entitlement to a determinative view on the matter, and one which, moreover, should be treated as equal to that of Palestine. So a state that has no legitimate entitlement to play a role in determining Palestine's claim of statehood, and of course through its actions is undermining the validity of that claim, is given an equal voice to Palestine when the claim is being assessed. And through all of this, the Palestinian struggle is being pushed further into the box of an approach based on statehood, both for Palestine and Israel, with all the broader implications this has. The international human rights law system, then, while ostensibly simply being concerned with protecting individual rights, actually also requires the Palestinian people to frame their struggle through the paradigm of statehood for both themselves and their colonizers. Now, assuming that the Racial Discrimination Committee affirms Palestine's claim to statehood and then looks at the complaint, it will only be able to do so as far as those aspects of the complaint that relate to the situation in the West Bank and Gaza, if the committee concludes that the convention applies to Israel extraterritorially. The question of the extraterritorial application of human rights law brings to the foreground the fact that for most of the 70-year period of the Universal Declaration, international human rights law was understood to apply only territorially. During this period, the position that the West Bank and Gaza are not Israeli territory, had the effect of excluding the operation of Israel's international human rights obligations to it in relation to the occupation. And if Palestinians had wished to invoke these obligations in relation to Jerusalem in particular, they would have had to accept Israel's claim to sovereignty there. Thus, the international law position mirrored that in the supposed protections offered by domestic Israeli law, where similarly Palestinians must utilize a legal system that has been purportedly extended to Jerusalem on the basis of Israel's claim to sovereignty there. The operation of the legal human rights protections, then, are of necessity tied to Israel's sovereignty claim. To invoke them is to implicitly affirm the validity of that claim, since they wouldn't be operable were Israel's claim to be without legal effect. Given that Israel's assertion of sovereignty and its application of domestic law to Jerusalem is supposed to be illegal as a matter of international law, the exclusively territorial conception of international human rights obligations required Palestinians in Jerusalem to either forego modalities to invoke their rights or to accept the annexation of Jerusalem. The exclusively territorial conception of international human rights obligations also, at a stroke, excised the issue of the refugees and their right to return from the purview of these obligations. Yesterday, Raif Zereik raised the problem with self-determination as creating, and I quote, a right to close your borders. And there he is at the door, maybe just coming in just as I mentioned his name. When we're focusing on the exclusively territorial conception of human rights obligations mapped onto the Israeli state, it's perhaps better to see this not so much as the right to close borders, as the right to exercise complete discretion about who to let in. This enables Israel to simultaneously close its borders to Palestinians and to open them to Jews, thereby denying the right to return and enabling the further demographic transformation in a Jewish direction, which of course is a mutually reinforcing process when the land and property of Palestinians displaced in 1948 ends up in various ways being deployed for the benefit of Jews migrating to Israel in the period since then. Again, this is linked to the consequences of statehood, given how the silences of international law on most questions of immigration admission by states enable entities treated as states by international law, like Israel, to conceive themselves as bounded demographic communities as they see fit. Of course, the very day after the Universal Declaration was passed, the UN General Assembly adopted Resolution 194, which affirmed the right of return. The exclusively territorial conception of international human rights obligations that predominated for much of the 70-year period since then removed the implementation of this right from the purview of international human rights law. International law then offered the promise of human rights, combined the very next day with the affirmation of the right to return, only then to close off a focus on the latter from the purview of the former. Relatively recently, however, it's become accepted that international human rights law applies extraterritorially as well as territorially. So now, as was not the case before, international human rights law can be invoked against Israel without making any assumption about Israel's claim to sovereignty over the place in question. And indeed, one of the seminal articulations of this position is by the International Court of Justice in the Wall Advisory Opinion. This is undoubtedly an important shift. International human rights law now diverges from the position in domestic Israeli law, and it's commonly viewed as a progressive development in human rights law generally, and potentially of great significance to Palestinian rights in particular. However, this is where I will draw my remarks to a close, but there's so much more to say here. The conventional view of the extraterritorial application of international human rights law is that it only operates if effective territorial control is exercised in a similar fashion to occupation law. So it only addresses a subset of determinative extraterritorial power dynamics operating as a matter of fact. Because of this threshold requirement, states can calibrate their extraterritorial projection of power in a manner that enables them to make a plausible argument that it falls short of the test and is therefore not covered. Palestinian refugees outside Gaza and the West Bank don't fall within any conception of this effective control test, so as to bring them within the scope of Israel's extraterritorial human rights obligations. So then, what is billed as a progressive shift makes no difference to the exclusively territorial conception of human rights law, as far as the right of return is concerned, for refugees outside Gaza and the West Bank. This is then a distorted frame of reference, not of the situation in 1948 when the Universal Declaration was adopted, but only after 1967. And indeed, it's notable that all the modern international human rights treaties only entered into force in the post-67 period. And in the West Bank and Gaza, just as with the test for occupation law, the threshold requirement of applicability leads to ridiculous debates about whether, for example, Gaza is somehow subject to the necessary level of domination and oppression by Israel to warrant the operation of Israel's human rights obligations, as if this is not tragically and horrifically clear for all to see. In the case of occupation law, the effective control test enables Israel to argue that somehow this is a boots on the ground test, which therefore is inapplicable to the control it exercises by sea, air, and at the borders with respect to Gaza. Although Israel continues to maintain the position that international human rights law doesn't apply extraterritorially at all, the similarity of the tests in both areas of law enable the same sort of argument of failing to meet the applicability test to be made in relation to Gaza. That it's even possible to make this argument illustrates, and this is where I will end, one of the paradoxes of human rights law, that people subject to colonial domination must, in order to access an international system that somehow claims to address this, they must first of all convince that system that the domination they're suffering is deserving of the attention of that system, in the face of arguments put by the very actor responsible for that domination that they are not. It is for the international system, not the Palestinian people, to decide how Palestinian oppression and colonial domination is both to be characterized and whether or not it's worthy of critical scrutiny, and according to a test that is only anyway intended to cover a narrow subset of extraterritorial power dynamics. So to conclude then, I would simply echo what Samira said yesterday, that we can see, I hope in what I've illustrated, how using Samira's words, the project of human rights law has reconfigured the horizons of political and ethical possibilities, diminishing the pursuit of collective freedom adequate for a non-colonial future. Thank you.
Thank you. في صوت. Okay.
Thank you, Ralph. In the discussion, there will be several questions. Thank you. We will have, but then the next panelist is Reem Butme, who is a researcher in law in Birzeit University, and she is concerned in law and society and social and legal studies about religious courts and what she calls the advance of procedural legal thing, especially in religious courts, and we see it in different aspects. So you have 20 minutes, please. I want to work on religious courts, but I want to disappoint Sana. I want to address to what degree these religious courts fit or do not fit with the accords, and to what degree it is achieving human rights. And this will not be part of my discussion. I'm looking at religious courts as a scene of an existing conflict that was historic. It is not contemporary. It has different frameworks. And speaking about the contemporary state and this APLAC, it has its ethical and political and social dimensions. And another concept that in Islamic precedents and religious courts have been formed, it is not the same that was existing before the reform during the Ottoman period, the Tanzimat that is, and it entered within the modern state paradigms. It does not diminish its authority, as some prominent writers have said, but it has to do with the concepts. In my intervention, I deal with the basic premises that deal with the women rights and international, and to extend the human rights to the margin that the religious courts engage in. This margin has its own traditions, precedents. It has to do with Islamic norms. It has been altered, although it was never cut, and it was connected with specific traits that it introduces itself, that it belongs to such traditions. So you have religious judges who are not necessarily jurists, but people who study the Islamic Sharia. Within this framework and in the contemporary developments emanating from the establishment of the PA and reorganizing the concept of state formation within the Palestine, there is a new format of religious courts. A basic component is the inclusion of human rights, international law, human rights. So including this, giving it a wider focus, it seeks to impose to gain bigger space within this space, which is within the civil system of the modern state and its concepts. Whether this system has to do with specific concepts and procedures, and to have a definition of the judge and related to the court, whether it is how to deal, the modus operandi. Those who visit 5 years ago, you notice that on religious court, within every title, that you cannot consult with the judge. They used to consult him previously, but in the relation with the subjects, and so to consult it used to be. So this has a diminishing of the role of the religious court and shaping new relations. I refer to several issues related to this and review it within such interventions or invitations that require the religious courts to fall in line with its procedures and having to do with civil law. Inheritance was one aspect, a new concept, which is people who sort of leave religion, in a way, renegades, and to be related, where you have people who are renegades, who sort of fall out of line from commonly established religions, and how this is viewed. The third thing in religious courts, that it wants to be part of the state modus operandi, not only the international humanitarian law one, but also they want to be part and parcel of the legal business. So the religious courts often reiterate that we want religious training. What is the court, the concept, how we deal with it, what are the procedures. This became a desire. They are looking forward to become part of such a system and cope with it. So organizing from 1997 until now, there has been building the religious court operandi that fits. We speak about early instance court, appeal court, and the high court, about a prosecution which falls in line with the Islamic Sharia, and that sort of feeds the existing practices. I want to see how such structures want to intervene with legal court, where you have a close relation between the civil and regular kind of legal system and the Sharia court, which creates a situation where such invitations want to renovate the control of the state and not applying human rights. We know that the essential idea, the focus is to bring in the state in the process and reinvent such a space where it appears from a security point of view in the inheritance laws. It's not how much they share, but also you have to deal with the security apparatus and to take steps in order to facilitate your having access to the inheritance, although everything should be part of a procedural pattern in the courts and seek such attempts. I want to start about renegades or people who go astray from religion. It has to do with people belonging to the Ahmadi sect, that this is a kind of aberration from Islam, that these people are outlaws from proper Islamic traditions. I don't know whether this is right or wrong, but why did this movement or these issues surface? Although this is existed since long time, and the legal courts deal with such a phenomena in different levels within hurdles related to marriage in an attempt to get a divorce as one of the background, or to complicate the issues related to marriage. And religious courts dealt always in an essential way within such a framework of considering it outlaws. And the courts, they said that the person did not deviate from proper religious attitudes. The court used usually to take that the person is still a Muslim by witnessing the two kind of swearing. This is the basic requirement, that paying allegiance to God and His Prophet. But in 2010, a sort of dispute surfaces where you have the religious prosecution was formed first at the time, 2010. This religious prosecution has a new concept, which is the right of the Almighty in according to Islamic Sharia, where you have the public right, and you have within the Sharia court that deal with such issues. So this is the right of the Almighty that deals with a specific ethical background. It is not purely legal examination that the state should undertake to people within the concept of public order. And so this issue, which is part of the bickering of a family and between that has takes a different meaning. So it becomes part of the religious obligation. Who is allowed, who is not allowed? What is the choreography of religion? And as such, it provides a greater space for the state to interfere uh, in, in specifying what is the essence of religion and what is kosher and what is not. So within this renegade system, that the court has to make sure on the facade that the person is certainly a Muslim. They don't take intentions. It doesn't get involved in is this actually believes earnestly in what he says. This is not the work of the courts. They deal with what is on the facade, not on the essence, especially things that are associated with the right of the Almighty. The religious courts deal with what is visible, but the internal dynamics is not part of the responsibility of public order. It's not a public order, but this is referred to as it is sort of an absurd kind of it's not visible. So when there was a prosecution that has to check the thing, and you had the high courts to define what is the range of the court application, so it became a legal interpretation issue according to civil content, that it is not human rights which is sensible to the concept of being a renegade or the transformation as a result of being part of the public order. So this kind of sensibility, which is contrary to the idea of human rights, that human rights are not sensible to the concept of the state and the way it views things. It doesn't seek to intervene or abort or interfere, but it should be held under discipline. So human rights issues do not say we don't need as exceptionally issued court rulings by the state. What is relevant, what is not. And I think it's more important, pertinent to say that the authority legislates within the concept of human rights. I want to return to the personal status issues where you have the interference of the state that has to do with the contemporary laws within the Sharia courts and its tools. So the concept of renegade became part of the general thing that the religious courts would have been established recently and to be discussed. The issue, we have also a Supreme Court that needs also to check and issue its rulings. So the court came for the higher courts. And essentially, in Sharia courts, there used to be one, and there are no exceptions. There are appeals now, and you have different levels of courts. And the Ahmadiyya sect, that as the court functions, try to investigate and to ask them to give the two oaths or witnessing to ask breaking the marriage for custodianship, that the mother or the father, about the children, that is, custodianship. So it went to the appeal court of appeal, that the early instance court has went, and we asked in order to break the marriage. The Supreme Court have to show their prowess. And they said, you are not applying the thing, you're not doing it kosher. I mean, there is no renegade law, but in the Hanafi sect, you do not have a clear text. So the Supreme Court has to show prowess that it has its mandate. So it said it is not enough for the person to prove is a Muslim, or that he denies being the Ahmadi. So the Supreme Court here has moved the issue into a wider dimension. So there were legal procedures that gave a different concept of controlling a renegade. So ethically, they want to say that you are still a Muslim, or out of this without intention, without so on, to have a greater control, in other words. And you do not want to make sure that you are speaking the truth. The Sharia courts do not seek that. They don't go that far. They want, in order to maintain, in order to visibly have this, not to probe deeply. In other words, this model of intervention legally happens redundantly and have to do with issues related to inheritance, and the state should interfere. So we have to put, say, procedures in order to safeguard the rights of the women, for example. So, and I went and worked on religious courts on such issues, and I saw that this main claim that the religious courts, we should bring in the state within its range of concern. So let us start digging into it. And I knew that on issues of inheritance, for women it became difficulty to deal with inheritance. You need 2 to 3 months, according to your relationship with the security apparatus, in order to get an inheritance thing. It used to happen in 1 or 2 days, the bureaucracy. But now the legal and administrative steps, where you have lands on sea, and you need from preventive security a clearance, and they just file it until you bring somebody to interfere. You know, they look at the file in case you have favoritism, and the issue is to protect public interest, and to prevent land from being leaked out. The other issue is that you have to look, you have a court of appeal and the Supreme Court, and this will take time, red tape. So we should take, and you have in the inheritance control that you, so this takes, a long while until it goes from one court to appeal and then to Supreme. And if you do not have people who will help in moving, maybe it could take 6 months to take a heritage index. In the Sharia court, it used to be in 1 day, and building its relationships with the employees, and where there is confidence until you get it, that it requires within the modern legal framework. And I would like to conclude with the issue, to what degree such interventions basic that we request by human rights concepts, it takes into consideration it's a sensitive issue having to do with the regular court procedures that tries to enter into the actual margin of Sharia courts and what it does on the ground. I want to give another concept in its discourse of a certain issue within a certain context having to do with the religious courts in Palestine.
Thank you. According to the program, we have only 17 minutes, but we can take 5 minutes away from the break. Let us start with questions or comments. Please introduce yourselves before you do the thing. Islah Jad. Question to Dr. Reem. You were saying that the Sharia courts are part of this system. Why? Should be part of this system. Why is that? Why should Sharia judges be a part of that system as well? Question to Mrs. Marina. What do you mean by the non-intervention of international law in states, even though it governed the relation between the states? Second question, you were saying that different laws were passed with regard to racism. Who or what was the body that passed the laws against racism? You said that there was the passage of laws about 10 years after the 1948 declaration. Which parties passed those laws and what? Yes. Laws against racism. Okay, so question to Mr. Raphael. Palestinians, when you said Palestinians should recognize the rights of Israelis, what did you mean exactly? Could you please explain? Let us take some questions from this side and then we move to the other side, so as to be clear, please.
All right, I just had a question for Marie.
لدي سؤال لمارينا.
I was wondering if
كنت أتساءل بدأ الأمر. شكرا لكم جميعا على عروضكم الممتازة.
it was a great talk.
مارينا,
You said, but have you given any thought to why there is this distinction between the trend in the inter-American court and the European courts, and whether that might be tied in some ways to the settler colonial experience in the Americas and the fact that it is a relatively new migration and what has happened to the indigenous peoples?
Thank
أمريكا بالسياق الفلسطيني لا؟
Miss Marina.
To Rina, Mrs. Marina, you said that Europe tried to enhance European values all over the world, to spread and globalize them, and that they constantly called for human rights and so on. And you also mentioned that the European states sometimes abused and did violations in several countries. This could be correct, but except in the case of Palestine, because we see double standards in the case of Palestine, double standards with regard to Palestinian human rights. What do you think about that? What we saw double standards, especially during the Cold War, when the Europeans were kind of were promoting the Eastern Bloc people to run away to Western countries. human rights was being abused in order to stand against the Eastern Bloc countries. That could be one of the best examples on how to continue the Cold War. They didn't really care about human rights. It was more about politics. Now, the support of dictatorships all over the world is another example on double standards by the West. For example, that there are many countries, dictator countries, which do not respect human rights. You still do arms deals with them by $100 billion, like with the UK. The UK claims that it cares about human rights. How can it go and close $11 billion deals with dictator countries that violate human rights? So you see double standards all over. It seems like human rights are only for European residents. State of Israel is another example. Many countries consider that Israel is a country that respects human rights, but in reality, they are abusing human rights on a day-to-day basis. From the Jordan River to the Mediterranean, from the north to the south, we see oppression, violations, and even stealing people's lands. So how do you see this? Thank you. Okay, let's move to the other side on the left from us. Okay, since I have the microphone already, I will ask question to Mrs. Reem. You were talking about the absence of Sharia courts. Okay, I'd like to ask a question. I know that there are other issues that are currently being dealt with by the Sharia courts. What are they? For example, divorce and so on. What do you see the role of the Sharia courts in this respect? Two, we expect that the Sharia courts would take into consideration human rights. What's your view on that? Is there any specific role or a party that specifies and clarifies the role of Sharia and religious courts? How should the religious courts act under the human rights considerations? Hello?
I have a question for Sana. I thought it was very interesting, the intervention, but I was missing. I thought that to produce possibilities of real change in regarding women's rights, and I think we should pay attention and identify dynamics, historical dynamics that we have witnessed in Palestine, especially since the inception of the PA. And the first one, I would say that to revise your assumptions that we are a nation in transition to statehood and democracy. I mean, honestly, what I see is exactly the opposite. We are in transition, it seems, to a non-state, which has the shape of a dictatorship to me. So first, and I think that has a lot to do with the possibilities of change, constitutional change and new political dynamics. But also there is an element there very important, which is this all PA, not only PA, PLO, PA trope that we need to fight first for liberation, and then we will take care of the social things, included women rights and etc. And I think the third thing is that we should also pay attention to the, I think, important work that women movements have, and I think has still in Palestinian politics, but especially at the beginning of the Oslo Agreement, and I'm talking about organizations like WICLAG, the Women Technical Committee, people who were involved in these issues and produce good results. Thank you.
Thank you. Samira?
شكرا
Thank you
خلال
for your
Professor
interventions.
Ralph,
لدي سؤال.
some people in the audience didn't attend your talk, and I want you to reflect further on a certain point for their benefit. So, but it's a genuine question. The various sites of international law that you've investigated and shown how they force the logic of statehood on both the PLO, but also the logic of recognizing the colonizer's state. Are there other sites in international law that do not force this logic, or is it inherent to any attempt to join the international community or to join to be part of that international family of nations and to either directly or by taking part in its various sites? So can you see any other site in international law for a colonized population that does not force that logic of statehood? And what is it, if there is? Thanks.
شكرا. ايش
في هذا المنحى. We can only take 2 more interventions, if you may, or comments, questions, what have you. A comment to Mr. Ralph. I only saw a part of your lecture. You were saying that if someone is occupying the land of someone else, it seems like it is in charge of the affairs. I think this law doesn't apply to Israel because Israel in itself is not legitimate, is an illegitimate entity which took the land forcibly and kicked the people. Israel in itself is illegitimate. So how can it be considered legitimate globally? And then you were talking about the right of return law. This law is quite fragile. Yes. There should be a law which calls for the forcible return of people, whether Israel wanted it or not just a right of return law. And then there are so this law is quite fragile about right of return. It seems like it is a suggestion. No, there should be the compulsory comeback or return of people. Israel must understand that they forcibly took the land, and Israel is a country that was illegally established on the account of another people. Okay. Good morning. A question to Mrs. Marina. Do you think that the security consideration can be considered legitimate to violate the rights of refugees for the sake of security and the state? Question to Mr. Ralph with regard to the sovereignty or the sovereignty of the state. In the case of Palestine, it seems like the sovereign parties here are Israel and the PA, but it could be also great countries like the powers or like the US or UN. And a comment to Miss Sana. Israel could be one of the very few countries which do not have a constitution. And during the constitutional meeting with Mahmoud Abbas the other day, he said that one of the requirements of the UN to recognize us as a state is to have a constitution. But Israel does not even have a constitution, and it is recognized by the UN. Also, the participation of women is not there. It seems like the constitution has become a politicized thing more than anything else. So my question in particular is as follows.
اتوقع انه الدستور مزدوج اذا كنا
سنة
عندنا حل دولتين
do,
ممكن هذا الدستور
if we have a two-state
يراعي
solution, do you think
الاثنين
that the constitution would really help the Palestinians who are living under the or would live under the Zionist entity? Do you think it would be beneficial? And thank you. Okay, let us start with answering these questions. 2.5 minutes for each. I know the time is limited, but let us try to stick to the time.
Thank you for the questions. For your question about the question if the declaration and the human rights have a colonial and European reality, I'm according with you. And the Galin, her name is Jorge Rodrigo Bandeira Galindo, is a professor, is a Brazilian professor. He said that there was despite the emancipatory potential of human rights, the language of these rights has been manipulated through of the hegemonic powers. I'm according to you, and for we grant the human rights and necessary to be aware of the oppression potential of the universality of human rights. For me, it's necessary to make analysis of the regional dialogue of the human rights to be guaranteed the really human rights and not European or I don't know hegemonical power or of hegemonical language. About the question if relate the inter-American system, I'm a big fan of the inter-American system. Because the inter-American system for me it's same different of the European system. Understand the modernity and the construction of the human rights in the Americas starts with the discovery of the American, according to Aníbal Quijano and Henrique Dussel, Argentines professors. In this sense, modernity brought with the colonist a hierarchical partner of powers and chronology to maintain the domination of the people of the global south, and they are at the ideological discourse and intersubjective levels. In this sense, the Inter-American Court of Human Rights considered the requirement of equality and non-discrimination to alteration the conception of hegemonic and universal rights. In this sense, the Inter-American Court recognized like the non-refoulement, like a just causes, and the prosecutors like a just causes, the indigenous people's rights like a just causes, and the European Court of Human Rights. This is never possible. For your question, if I understand the change of the declaration, the past, the comprehension of the human rights, is this okay? For me, this change is never. This change don't wait a minute. This change. This change has not happened because everything and everybody work the human rights course about Europe and the United States discourse is fundamental of intervention or discourse of the study of human rights. Me and you possible study human rights about the press post of Europe and America, United States professors, books, and everything. And one that I remember is your question. I don't believe the last question. Yes, your. No. I'm sorry. Interventional international law. I'm sorry. The intervention law. Yes. Yes, and the utilization of the security, like a legitimate the intervention or international law. Well, in the European system of human rights, United Kingdom every time utilize the security for fundamental tortures, violations of human rights, and for me, it's not possible. Besides the security for violations of human rights.
Emilio, thank you for your question. I think I'm going to answer you in English.
سأجيبك باللغة الإنجليزية لكي أقوم بالإجابة عن السؤال. إذا فهمتك جيدا، أنت سألتني أن أنظر إلى مرحلة التحول هذا. سبب قولي بأن فلسطين تواجه منطقتين أو متحولتين هو كالتالي، لأنه هناك تحول إلى الديمقراطية وتحول في الدولة. هذا ما أعتقده. أعتقد بأن هذه المرحلة طويلة، نعم، ولكن يعني هذه المرحلة ترتبط بحقوق الإنسان وما شابه والمجتمع المدني. أنا أرى بأن هناك تقدم معين في المجتمع. أنت صادق بأن هناك بعض التحديات المرتبطة بالدكتاتورية وما شابه. نحن موجودون بهذه المرحلة، ولكن نحن ندعو بالانتقال نحو الديمقراطية والمجتمع المدني الحقيقي، ولذلك نحن نحاول النظر لأمثلة أخرى أو دول أخرى للاستفادة منها. حول الدكتاتورية كلامك صحيح، ولكن يجب علينا أن نعطي أملا للناس لكي ينتقلوا لمستوى أرقى ووضع أفضل في هذه الديار. وقبل الحديث عن عملية تطبيق الدستور يجب صياغته بأفضل الطرق. وعلى سبيل المثال في دستور عام 2016 كانت هناك الكثير من القضايا الناقصة. لماذا؟ لأن القضاء لديه مشكلات عويصة وحقيقية، والأشخاص الذين قاموا بصياغة الدستور كانوا كلهم رجالا. ولذلك قبل النظر للحقوق الدستورية اقترحت بأن نبدأ بتصليح أو إصلاح الكثير من الأمور. إذا حتى الأشخاص الذين صاغوا الدستور أنا تحدثت معهم ورأيت بأنهم لا يأبهون بالنوع الاجتماعي في الدستور، ولم تتوفر في أيديهم الأدوات المطلوبة لوضع دستور يرتقي إلى المستويات العالية. ولذلك أنا تحدثت عن تهميش المرأة في الدستور، لأن المرأة الفلسطينية تلعب دورا هاما جدا في المجتمع الفلسطيني. كانت المرأة الفلسطينية دوما في المقدمة في صيانة الحقوق الفلسطينية والكفاح والنضال الفلسطيني، حتى عندما تم توقيع أوسلو وغيره كم من مرأة كانت موجودة هناك، شبه معدوم وجود المرأة. ولذلك نعم، إجابة لسؤالك مرة أخرى، يجب علينا أن ننظر إلى الأمام وليس إلى الخلف أو الدكتاتوريات وما شابه. I spoke less in order to be able
بس خليني
in the questions. Let me answer the second question or the third question. Countries do not have to have a written constitution. Even Israel has basic laws. They have basic laws, even though they do not have a constitution. That is also fine. If you have basic laws, that actually governs and regulates the country in the best way. So in my presentation, when I was talking about how the basic law was written, you noted that, as the president said, one of the basics of recognizing us is the Palestinian constitution. I personally think that we need to have a constitution and a basic law, because if we didn't have that, then we would have much more, or if we don't have that, we would have much more problems. If there has not been a basic law in Palestine, more problems would have happened on the Palestinian level. I think that the constitution is like the birth certificate of countries. Therefore, laws should be written well in order to regulate and govern and also preserve the rights of people. As for the last question, with regard to this, if there is a two-state solution, would the Palestinian constitution include the Palestinians of 1948? I would say no to that question, because there is territorial jurisdiction, and the Palestinians of 1948 would probably be under Israeli law in that case. Palestinian all constitutions in the world are limited to a geographic boundary. So if there is a two-state solution, I do not think that at any time it would include the Palestinians of 1948. And thank you. Yeah, you can talk during the break, Mr. Ralph.
The third question, that all the questions with the three were linked in the sense that, is this on? No. Can you hear me? So the concern that to place the legitimacy of Israel into question, and indeed what I'm suggesting is that to have recourse to these international mechanisms of enforcing international human rights law necessarily assumes Israel's statehood, since the mechanisms are exclusively open to states and the obligations that are applied by them are obligations of states. So to bring a complaint against Israel to one of these institutions is to presuppose Israel's statehood, and therefore implicitly is a recognition of Israel's statehood. So, Samira, are there other sites in international law that don't, as I've just explained, these sites do force the logic of statehood? Were the world different? And this is the problem. And it is the nature of international law itself that is not specific to human rights treaties or the United Nations. This is the international legal system, which is based on an assumption about the ordering of human relations in the world according to the division of the world into sovereign states. That said, this is very much cold comfort, given that that's the main answer. But then how states are defined is itself a matter that is open to contest. And so what the state is, so within the logic of statehood, there are possibilities for contest there, and what the state covers and who its population and its territory, for sure. And in a longer version of this paper, I would have potentially explored, I will explore how these different international legal instruments sometimes attempt to define statehood for the purposes of the instrument in a sui generis way that may be somehow different from how it's defined in other contexts. And that is playing out actually in how this question of Palestinian statehood is being decided by, for example, the prosecutor of the International Criminal Court will be addressed if this case brought against the US ends up going before the ICJ. That court will have to say, does the diplomatic relations treaty somehow have a definition of statehood that's somehow sui generis, and what would that be? So there are ways in there to potentially to making different disruptive arguments. Of course, unlike human rights law, international criminal law is about the obligations of individuals, not states. And therefore, to make a claim of utilizing the jurisdiction of the International Criminal Court does not require an affirmation or an implicit recognition of Israel as a state, unlike bringing a claim under a human rights treaty, which is then a claim about the state's liability, not individual liability. International criminal law is only about individual liability without prejudice to the status of the entity in whose name that individual acted. However, it still requires a system of reinforcing the logic of statehood, because the jurisdiction of the ICC is only triggered if Palestine is itself constitutes itself as a state, and on that basis ratifies the Rome Statute, which then in turn enables the prosecutor to consider the situation in Palestinian territory on the basis that that is the territory of a state that is a party to the statute. So the logic of statehood is still actually required, and that feeds into what I was suggesting more broadly, that these instruments that claim to be about individuals and individual rights and somehow then beyond statehood are actually in many ways operating entirely within and reinforcing the logic of statehood and state sovereignty.
اوكي ثانك يو ظرف ريم ممكن خلال دقيقتين
نص دقيقة
لا دقيقتين
بس بإجابة سريعة
Just quickly to answer the comments
قضاء شرعي بده يعمل هيك
with regard to the Sharia courts and how they should be. Well,
دور القضاء وشو بده يعملوا
there have been discussions about the roles of judges and what they will do, and so on and so forth. There has been also a conflict, and such conflicts, such as in 2002 and 2004, led to the resigning of several Sharia court judges. There is a disagreement with regard to the transformation and so on in these Sharia religious courts. Also, today we see that the legal discourse is the one which is prevalent. What I am saying is the opposite of what Sana is saying. That I am looking at the different angle and how the state would come and tackle the issue of the courts. So in the international conventions give the states the sovereignty to and the authority to tackle such issues, such as the general order and security and what have you. So I do not think that what you said is an issue of disagreement. We actually, I agree with what you are saying. So what I think is that new legal models must be introduced in order to make our legal court system more effective and more prevalent. We had about 15 minutes delay, but now we will take 10 minutes of coffee break. 10 minutes, and then we move to session 2 with Hala and then the speakers. Thank you very much for the speakers of session 3. to session 4. So please, welcome, most welcome. What? Oh, thank you. Perfect. Thank you. We have started a bit late, and therefore we will try to be quick, and especially since there's lunch after this session, and that's why we would not want to be late. Quickly, I would like to say the following. I am Hala Shuaibi. I teach international law in the university here, whether in the BA or other graduates. Most of my study was traditional international law and about the development and so on. Later, I came to learn about 12. So, from this perspective, they look at it from a different angle. Until today, we have been looking at until 15 years ago, we were looking only at the European perspective. Today, in the last 15 years, they are looking more on international law from the perspective of the third world and including the Arab world. We have 3 papers talking about different subjects. The first one will be with Osha Natajan, who will talk about the natural resources and the Palestinian environment. She will talk about how the elites are using or abusing rather the natural resources of the world. And we will talk about how much it is important to control the resources. The second paper is for Sujith Xavier, who will talk about the human rights complex, a site of emancipation for people of color, talking about colonization, imperialism, and occupation, and why we always resort to the International Declaration for Human Rights. And John Reynolds will talk about the internationalization and the image of law, anti-colonial solidarity, and the Russell Tribunal on Palestine. He will talk about this subject and will cover some of the problems of emulating or copying the international law in general in the Palestinian context. Osha, تفضل.
So thank you, Mudar and Joyce and all the organizers for this wonderful conference. And my particular thanks to Joyce for her really incredibly considerate attention to detail and making us all feel so at home here. And of course to the translators for all their hard work. So our panel is called Third World Approaches to Palestine. So before we get to our presentations, I just want to explain that our title is in reference to a political movement called TWAIL, which Marina made reference to in the earlier panel, or Third World Approaches to International Law. We are addressing diverse issues today, the 3 of us, and we have diverse methods as well. But what unites us is that the 3 of us are part of this movement and share this political commitment. So TWAIL is basically a global network of scholars and practitioners that seek to understand the colonial legacies of contemporary international law in order to decolonize the lived realities of people in the global south. And so TWEL's been going on for about 21 years now, and the three of us have taken an active part in this, and we've written and organized and plotted and conspired together on academic praxis for a while. So we want to change the way knowledge is produced in our discipline, including through a daily academic praxis of bringing in voices and ideas that are systemically excluded from a so-called international law. So it's in this context that I particularly appreciate the opportunity to come to Palestine. TWAIL is heavily influenced by post-colonial theory, and so there is a risk that a movement that focuses so heavily on the challenges of the post-colonial state may not be sufficiently cognizant of those who remain colonized and how we should strategize in solidarity and in alliance with them. And it's actually thanks to the work of people like Sujit and John that this has actually not happened within TWAIL, because John, as many of you know, has this long-standing insightful work on Palestine, and Sujit has been a dedicated advocate in his research and practice for solidarity with indigenous peoples. And so they, along with other colleagues, have been a real example within TWAIL for me and for many others about how important it is to come to spaces like this and to learn from you all. So thank you for this opportunity. So let me start with my presentation. I think I'm the first person to talk about the environment at this conference. So on the 70th anniversary of the UDHR, I want to reflect on the usefulness of human rights for addressing the challenges facing the environment, particularly the Palestinian environment. So I'm going to discuss in three parts. The first part is what are contemporary global environmental challenges? The second part is what are the challenges in Palestine? And the third, and the main point of my argument, is how does human rights help or hinder addressing these challenges? So because we have not focused on environmental issues in this conference so far, I should probably start with a brief description of what these challenges are. So for those of you who managed to not know about this, we are in an era of environmental change. So we're in the middle of the 6th mass extinction. A mass extinction is when more than 75% of species go extinct. And the last one was 66 million years ago in the Cretaceous period. So while we don't always know what causes a mass extinction, most of the ones in the past we know have had something to do with climate change. So that's the other issue. The climate is changing. Climate change, as with mass extinctions, is not actually unprecedented in planetary history. We've seen periods of ice ages and warming in the past. We've been in a period of relative climatic stability for about 20 million years, and that's changing now as well. So the period of stability is over. Marine plants in the oceans and the forests on land, these are the things that oxygenate our atmosphere, are disappearing at a rapid rate. The deserts are spreading, as we know in this region, and the air and the water and the soil is increasingly polluted with toxins, including the oceans, which make up the bulk of our planet's surface area. And all of these different changes interrelate in complex ways. So many of these things are not unprecedented in planetary history, but what is different this time is that it's the first time that change is driven by human activity. The first time that And so by human activity, I mean specifically rapid industrialization. So the challenge is for knowledge production, for disciplines of knowledge, is that disciplines like law or economics or political science or philosophy, the social sciences and humanities more generally, is that they assume that natural systems are stable. So they don't actually function that well when this is no longer the case. Environmental change at the scale that we're currently experiencing it presents a broader challenge for knowledge production in the social sciences and humanities more generally, including for our purposes today for international law and human rights. So as I mentioned earlier, these environmental changes are driven by industrialization. The Industrial Revolution began in Europe, and it was a process that was intimately connected with empire, with slavery, and with genocide. The industry in the imperial centers would not have been possible without the labor and the resources of the colonies. Labor was coerced through slavery and forced labor. Resources were taken through conquest and genocide. So in the post-colonial era, to be independent, you had to be a developmental state. Independence was conditioned on participating in the quest for industrialization. If you would not participate in this quest, you would not be permitted to become sovereign. And we see that in the fate of indigenous people in many parts of the world today. So an industrial development model that in its origins was peculiar to a particular culture and a particular history became gradually universalized and normalized through the process of colonization and decolonization. So as I said, one of the consequences of this 200 years of this development model has been environmental degradation. Another has been the increase of inequality within and between states. So the exploitation of the many for the prosperity of the few was not a matter of imperial history, but is in fact more of a reality today than ever before. So in a world that's increasingly unequal in power and wealth, how has environmental degradation played out? Well, unsurprisingly, it's played out pretty unequally. So to use an example from climate change, which is the issue that's most in the public eye nowadays. So climate change is caused by greenhouse gas emissions, and the United Kingdom, which has a population of about 60 million people, emits more greenhouse gases than the combination of Egypt, Nigeria, Pakistan, and Vietnam, which has a population of 472 million people. So the state of Texas, which has a population of about 23 million people, emits more greenhouse gases than the whole of sub-Saharan Africa, which has 720 million people. And the 19 million people who live in New York City emit more than the 766 million people who live in the 50 least developed countries in the world. So it's pretty clear that climate change is caused by the lifestyles of a few very rich people, and its impact will be felt by the poor and vulnerable masses. So given that we have these parallels between economic inequality and environmental degradation, environmental injustice, so for those of us here, those of us who are interested in the idea of human rights, my central point today is that we may want to consider whether there is a link between the way we treat nature and the way that we treat each other. So before I talk some more about this, I'll talk a little bit about the challenges in Palestine. I don't want to talk too much about this because obviously you know about this better than I do. This is my first time here, so all my information is secondhand, whereas you're intimately connected with many of these struggles. So I'll be quick on that part. There's obviously increasing environmental degradation here, and that has led to a fast-growing interest in environmental law here. And I understand that you actually had a conference here in Berzeit on environmental justice a few months ago. So, and that makes total sense because the military occupation and settler colonialism has created this serious and systemic environmental injustice in Palestine. So, among other things, there's a dumping of solid waste, sewage, industrial toxins. Some of these dumps are on top of really scarce and precious aquifers. They contaminate land, they contaminate groundwater, which then subsequently contaminates plant and animal life, including humans, and causes all numbers of diseases. And also air pollution also does this. So cancer, asthma, eye diseases, respiratory diseases from Israeli factories relocated to Palestinian land in order to protect Israelis from these impacts. So land confiscation, expanding settlements, the border, the separation wall, and various other apartheid policies, they divide and divert the water, they divide farms, they contribute to gradual displacement, urbanization, and a destruction of rural livelihoods. Is an inability for Palestine to fully access and control its natural resources in the territorial sea, in the continental shelf, and of course, certainly on land as well. And because the destruction of landscape is also tied to the destruction of culture, there's an impact also on, because the landscape is reflected in religion and spirituality and poetry and literature and all of that, and mythology and history. So all of that changes through changing the natural environment. And of course, Palestine is facing climate change. And unfortunately, the Levant is a region that is disproportionately affected by climate change. So obviously, Palestine is not a high emitter of greenhouse gases, but unfortunately, it's located in a region where it means it's going to feel the impacts more than many other places in the world. And this will exacerbate the impact on livelihoods, on increase in food prices, import dependency, things like that. The other difficulty is that if you want to litigate environmentally as a tort, or the various approaches that you have available to you when you're facing environmental degradation, you need scientific data. And there isn't a lot of monitoring of, so for instance, if you want to know where a chemical is emitted, what the chemical is, how the rates have increased, there isn't always monitoring of causality and risk from environmental degradation. But without this evidence, it's very hard to get redress through litigation. So, I mean, and all of this is unsurprising because, of course, in a state of occupation, it's very difficult to get it's impossible to get your procedural rights, such as access to information or participation or remedies. So I have been working on environmental justice. This is my area of research, and I've studied this problem all over the global South. And it is a field of research where inequities are unparalleled, yet the Palestinian situation actually does stand out as particularly heartbreaking. And so comparable situations, in my experience, are in Western China, in Tibet and Xinjiang, where we're also talking about decades of occupation, settler colonialism. And because these Western regions of China are where the natural resources are that fuel China's industry, there's no end in sight for the occupation. So in a situation like that, or in Palestine, seeking justice domestically is usually futile. Domestic courts remain under longstanding occupation, and they have all these institutional shortcomings. And you don't want to rely on the occupiers' courts because then you would be laundering and legitimizing the occupation. So in this context, it's totally understandable, the subject of this conference, the term to the transnational or the international for a solution to this, including human rights law is understandable. So is it going to be helpful? Well, in some ways it is helpful because human rights, despite some moves towards acknowledging communal entitlements, remain heavily mired in a very individualistic, atomistic understanding of life. And the good thing about this type of understanding is that it actually reveals inequities inherent in the causes and impacts of environmental degradation. It can show really clearly on a per capita basis that Israelis and Palestinians have very different ecological footprints. And it can also show differences in footprints between different classes within both states. So it can be helpful in revealing inequity of impact between and within states. But is it helpful in combating this inequality? Well, on the contrary, in many ways, human rights, through their compatibility with globalized capitalism, have over the last 70 years in many ways helped to enable this flawed developmental model that is at the root of many environmental problems. People all over the world understand their rights through globalized capitalism, which tells them what it looks like to live a good life, to a life full of rights, brainwashing the masses into fueling a system that ensures that they will be perpetually disenfranchised. It's in the seductive promise that human rights is useful to globalized capital, because the language of human rights obfuscates the impossibility of reconciling globalization with its ecological limits. 20% of the world's population consume 80% of its resources, and they urge the rest of the world to do the same so as to enjoy their rights. This is not an achievable goal. The discourse of human rights befuddles attempts to articulate environmental and developmental struggles in helpful ways in an era of fundamental ecological change. More seriously, the anthropocentrism of human rights may be part of the reason we struggle to imagine and express more sustainable ways of living. We're not atomistic individuals. Just as we're connected to each other and we value our social and communal tendencies, we need to be more aware that we are connected with the non-human world in the same way. A human cannot live for more than 3 weeks without food, for more than a week without water, and for more than 3 minutes without air. Every cell in our body is built from and continually dependent for life on everything that surrounds us, which in turn also depends on us, as we function in an intertwined ecology. In an intertwined state of being, where each entity's survival depends on its relationship with others within an ecosystem, the distinction between the human and the non-human is untenable. The non-human other is essential for human life. Whatever we do to the other, we're also doing to ourselves. In such a situation, it's misleading, it's inaccurate, and it's also very unhelpful to assert our rights as a species. Not only is it inaccurate, it's a type of thinking that evidences the very hubris that has led us to destroy the nature which sustains us. Oftentimes, people feel a sense of hopelessness and despair when human rights are condemned in the way that I have done now and others have done in the past 2 days. I actually don't, because I think there are unlimited alternatives available to us, narratives that human rights has displaced, but that can be discovered. I only have time, as my chair has pointed out to, in the time that I have left, I will just point to one in the Palestinian context, which is the framework of environmental justice. So alongside conventions on diplomatic and consular relations, human rights, humanitarian law, Palestine has recently acceded to the United Nations Framework Convention on Climate Change and has become party to the Paris Agreement on climate change. So under the Paris Agreement, Palestine has submitted its nationally determined contribution. And it said, essentially Palestine has said, we realize the importance of addressing climate change. And we also see strategic usefulness in joining this agreement. And it submitted these plans of what it's going to do to reduce emissions and also what it's going to do to adapt to climate change. And it clearly says, here's what we will do when we're under occupation. Here's what we could do if we were free. And there's a vast difference between the two commitments, right? So it's actually quite a strategic way in that sense, in showing that Palestine is willing to make a commitment as a global citizen, even when under occupation, doing more than other much more capable, much more irresponsible, recalcitrant states in the world. And Palestine can also urge the importance, through a commitment like this, of exploiting its gas reserves in its continental shelf, because this would be a means of meeting its Paris commitments, because it would allow it to achieve some of the energy commitments it's made under the Paris Agreement. And of course, this energy access will potentially improve its citizens' health and well-being. And also, like, very firmly conditions any of its achievements on getting technology transfer and funding from global environmental funds and directly from rich states. And access to this is usually managed through the Framework Convention. It's just quite a helpful approach to a protracted situation of violence, because it counters some long-standing familiar arguments like Göran Dinstein's, that when an occupation is very lengthy and protracted, occupation law must be adjusted accordingly. Well, environmental justice pushes against specious arguments like this, because it actually points out that the longer an occupation lasts, the more important it is to strictly adhere to occupation law, because environmental harm is cumulative. And over long-term occupation, then it's all the more important to attribute responsibility and accountability for harm done to the occupying power. And of course, Israel is also party to the Framework Convention on Climate Change and the Paris Agreement. It's also party to the Basel Convention on Hazardous Wastes. And it prefers to be seen as an environmentally responsible citizen, a global citizen state. So it's vulnerable to allegations of irresponsibility on these grounds. And the nature of environmental problems are such that even when you have very harsh, very cruel apartheid policies, you cannot necessarily contain indefinitely disease, toxicity, and environmental problems. So they are, on a certain level, they are a shared problem for both states. So in a situation where conflict is very normalized, has become very entrenched, I actually feel that there's probably more potential in frameworks such as environmental justice and various other frameworks to look at things to look at them in a new way, and to ways that incorporate a whole bunch of concerns that they were simply not thinking about when they drafted the UDHR. So that's it.
Thank you, and thank you for sticking to the time. Sujat, 20 minutes. Thank you.
Good morning, everyone, or I guess it's still morning. So first, I'd like to kind of reiterate what Usha just said in terms of giving thanks. Thank you, Mudar, Joyce, for the warm hospitality. It's really great to be back in Palestine. It's been a while since I've been here. Um, and um, and so I guess the paper that I want to present the title is The Human Rights Complex, a Side of Emancipation for People of Color. And this is a work in progress, and it's a piece that I'm starting to think about. And I want to rehash some of the old debates because I think it's quite relevant for us at the moment. So the UDHR, the Universal Declaration of Human Rights, is a crucial document with important rights that many have died for, and many continue to die for. This was particularly salient for me because of my own lived experience as a refugee from the northern province of Sri Lanka. My mother and I left the northern province of Sri Lanka because of the ongoing internal conflict between the Tamil Tigers and the Sri Lankan state in the 1980s. So the UDHR, to me, given my own personal experience, encapsulates the basic and inalienable rights people like me were owed. It has become abundantly clear, though, that law, especially international law, was not written for someone that looks like me, or for folks, a lot of folks that don't look like me that are in the room. So as I study the impact of international law on former colonial subjects, what is apparent is that international law and international human rights law in particular, like the International Bill of Rights, was designed to only protect a few. Yet many people of color, like myself, and indigenous writers hold on to human rights as if it may, in some way, deliver our freedom from the grips of white supremacy. And white supremacy is a framework that's quite relevant to this paper, and I'll get into what that means in a second. What I understand as white supremacy is the following. I pick up on Tony Anghie's or Anthony Anghie's work on sovereignty and imperialism, where he's characterized, I guess, the colonial encounter through the dynamics of difference, or what indigenous scholars like Irene Watson has coined as the arrival of the demon spirits on the shores of our lands and territories. She says the arrival of demon spirits, the Muldarbi, to me, or to her, is the starting point of her analysis. And I want to kind of use that in this paper. So in this paper, I want to explore why two scholars of color, Patricia Williams and Robert Williams, I don't think they're related in any way, why they've written so powerfully about the role of rights in our contemporary world. I want to first set out their arguments, then I want to offer some insights about why they're so invested in the human rights regime, and perhaps extrapolate about why it's hard for people of color and indigenous people to give up on rights, even though we know its very structure is meant to exclude us. So the paper is broken up into three parts. The first part is a little bit of a history in terms of the UDHR, which I won't get into too much, but now at the current moment, I live and work on the territories of the Anishinaabe peoples in what is now known as Ontario. And Canada has a really interesting history or connection to the UDHR. And any paper about the UDHR must give its true homage to the person who helped craft the document, John Peter Humphrey. He's the former dean of a school that I went to, and he kind of shepherded the process. And he's often celebrated as a figure that's forgotten. He was the chair of the Human Rights Commission, et cetera. And, you know, if you look him up, you'll find some really interesting accolades about him through the John Humphrey Foundation. And based on his work, Rene Cassin drafted the declaration, and he would later receive the Nobel Peace Prize. What's interesting, though, is to note that Humphrey was from a small town named Hampton in New Brunswick, Canada. What is now New Brunswick is the traditional territories of the Mi'kmaq peoples of Turtle Island. So Turtle Island is now known as North America. They were one of the first peoples of North America to encounter the white settlers as they arrived. Now they've been forced into 28 reserves in the province of New Brunswick, and their lives and traditions have been fundamentally altered. When the settlers arrived, there was close to about 2 million Mi'kmaq people on Nova Scotia. So you can imagine the devastation that's occurred, because now there's about 18,000 people that are left in New Brunswick. So it's important to kind of think about this history and also relate to some of the conversations that were happening about Jan Smuts yesterday, because the declaration was written by a number of white men that have shaped international law. And their role kind of gives us a window into the surface of what's on the text and what's also hidden, and what are the ulterior motives. So in order to understand why peoples of the colonies, so people of color and indigenous people, turn to human rights, I want to look at the scholarship of two scholars, as I noted. So Robert Williams, he's from the Lumbee Indian tribe of North Carolina, and he teaches at the Arizona Law School. And Patricia Williams, she is a law professor at Columbia Law School, and she is the great-granddaughter of Sophie Miller, a former black slave who was owned by Mr. Miller. And Sophie became pregnant at the age of 12. So you can imagine the type of relationship that they had. So in terms of the arguments that both Williams kind of articulate, they don't really deal with the UDHR, but I want to extend it. I want to extend it to the UDHR and how we understand it. And my interest in this topic kind of came up from a conversation that I think John was there sometime in London when we were hanging out with a bunch of Marxists, and they kept on asking us, why are people of color or scholars who are interested in the third world really unwilling to give up on rights? And there's a whole conversation that's been happening in the critical legal studies movement, and the reason why critical race theory folks split from critical legal studies was because of some of these issues. So let's get into what both Robert Williams and Patricia Williams say. So now I'm in the second part of the paper, and I want to focus on one of the pieces that Robert Williams has written, which is called Taking Rights Aggressively: The Perils and Promise of Critical Legal Theory for People of Color. And it was published in 1987. So what I love about Williams, or Robert Williams's writing, is the way in which he draws you in using indigenous stories. In this paper, he takes us through the reasons why his people need rights through a parable of an old medicine man. I don't think I have time to take you through the entire story, but it's basically about how we use our Western perspectives to think about remedies that are available for land claims or for enforcing rights. So in this story, the old man does not understand why his community is seeking money or compensation for the loss of land. He and his supporters want the land back. And I think this resonates with you guys, right? For a lot of the Palestinians, you want the land back. And you don't really care about the compensation. So basically, they want the white settlers with huge ranches to get off their land. So he convinces this is the old man, he convinces the community leaders to let him go and talk to the lawyers who are handling the case. And he's never been to the big city, let alone outside of his territories. So he gets to the office, he gets to the big city, he gets to the lawyer's office, and while he's inside the building, the old man has to take the elevator. And so Robert Williams describes it in the following way. Suddenly, the medicine man froze in his tracks. I hope, the old man said urgently, that you do not intend for me to walk through those doors. One of the associates, the lawyers, answered, why, of course, we want you to get into the elevator. The grandfather then said, I don't know what you call it, but all I know is that a minute ago, those doors opened and a man walked in. Then those doors closed. The next thing I saw, when the doors opened again, a woman walked out. That's bad medicine where I come from. After a few moments of explanation, the associates thought they had the situation under control, and the grandfather agreed to use the elevator. When they reached the offices, all the lawyers and the grandfather laughed and talked. So what Robert Williams does is he opens a window into how we understand rights. From a rudimentary take on the story, we might say, oh, the grandfather does not understand modern technology. But our framing ignores the fact that the grandfather is a learned man with strategies and tactics. We are viewing the old man from our learned lessons from the demon spirits, Western perspectives. The old man has tricked us and the lawyers. He is playing the Indian, Robert Williams says. Would you, and then Robert Williams goes on to say, would you feel as confident in your interpretation, however, if you knew that playing the Indian was a traditional strategy employed by indigenous Americans in dealing with non-Indians, particularly in situations of unequal bargaining power? Playing Indian, also known as playing the noble savage game, means to play upon the white man's own prejudices and a sense of superiority in order to assure that he underestimates your abilities. So rights, then, for Robert Williams, gives us, or people of color, a seat at the table. It gives us the language to combat the settler, the invaders, using their own language. More importantly, he suggests that it's easy to critique rights when you have never felt the lack of rights. For people of color and indigenous people, our daily lives are a reminder of what we don't have. For white folks and the crits, it's easy to critique rights because they've never felt the brunt of injustice, like being stopped at checkpoints, being asked where you're going, how long you're going there for, who you know, who you're related to, and then being denied entry. I'm sure this sounds fairly familiar. For Robert Williams, then, rights are part of the arsenal that indigenous people have in fighting off the white settlers that are constantly encroaching on their territories, changing their very essence of their being. So he writes, minority legal scholars, because of their unique positions of trust they hold from their people, must pursue a different non-minimalist path. Our immediate goal must be to transform the conditions oppressing our respective peoples. These oppressive conditions demonstrate the principles grounding the dominant society's legal and political discourse. That those discourses are corrupted and remain unrealized. These conditions, in fact, are the tangible proof of the failure of the rights theory. So for Robert Williams, we have to take a tactical position, like the grandfather. He says, we too must disassemble in an alien discourse of power and knowledge the treacherous and unfavorable terrain upon which we wage our guerrilla war for our rights counsels a strategy whereby we seek to be underestimated. Okay, so I know that I only have 10 minutes left-ish. Let me kind of paraphrase Patricia Williams's piece. It's one of my go-to texts when I'm teaching first-year law students and when I want them to get the lived experiences of people of color. Her texts generally read like a novel. And in this particular text, The Alchemy of Race and Rights, she looks at what it means to be racialized or a racialized or Black person in the United States in the 1990s. And I want to focus in on Chapter 8. Chapter 8, she tells the story of her experience as compared to the experience of Peter Gable, who was a white law professor at Harvard, and their journey in getting an apartment. So Gable, who's a famous critical legal studies scholar, kind of says, yeah, I bargained in the shadow of the law. I didn't really utilize any of the contracts, etc. And Williams is struck by this because she's like, really? That's awesome. But I can't do that because in the 1990s, Black women weren't trusted. Nobody would want to engage in this relationship with me and trust me to say, look, I will abide by the contract. And so from this, she kind of chronicles a discussion about why it's important for the Black community in the US to have rights. And she says, to say that Blacks never fully believed in rights is true. Yet it is also true that Blacks believed in them so much and so hard that we gave them life where there was none before. We held on to them, put the hope of them in our wombs, mothered them, and not the notion of them. And this is not the dry process of reification from which life is drained and reality fades as the cement of conceptual determinism hardens round, but it is the opposite. This is the resurrection of life from the ashes of 400 years old. From there, she goes on to say, rights feels new in the mouths of Black people. It is deliciously empowering to say. It is the magic wand of visibility and invisibility, of inclusion and exclusion, of power and no power. The concept of rights, both positive and negative, is the marker of our citizenship, our relations to others. So now let me move into the third part of what we can take away from these two brilliant scholars and their insistence that rights matter, even though we know it's part and parcel of the arsenal of white supremacy. Let me put it in another way, based on something that one of my teachers have constantly kind of said, and we all joke about it often. Professor Angie really loves bad pop culture, and he often makes really bad references to pop culture, but I thought this might be quite relevant, where he quotes to Hotel California by the Eagles to describe international law and human rights law. You can check out anytime you like, but you can never leave. And so in that sense, I think this is really important or human rights law is really important for people of color. We can check out anytime we like, but we can never leave. And so in that sense, there are three, I guess, rationales as to why people of color still believe in or hold on to and mother rights, as Patricia Williams has articulated. So if we were to go to Robert Williams, he sees it as a tool. It is a tool of white supremacy that he wants to deploy against the white settlers that have arrived on his territories, and he wants to use their weapons against them. Law and international law were the means by which Turtle Island was colonized. We have the immediate needs. We cannot continue to talk about the never to materialize revolutions of the old white men who read a lot of Marx. I have to, speaking personally, I have to give legal advice to my clients. I have to give advice to my family members, my niece and nephew, when they encounter the police. And we have to give them advice about a world that was built on white supremacy. And one way in which we can combat white supremacy is to invoke the language of rights. And look, we all know, or we know full well, that rights were never meant for us. These scholars are intelligent. The folks that advocate for rights are not naive. We know what we're doing. We've been doing it since the 1500s. Williams's ancestors, Robert Williams's ancestors, fought the European settlers from the beginning, and the indigenous people on whose land I now live are still fighting the settlers. So in that sense, rights for us or for people of color and indigenous people has an immediate or there's an immediate need for rights. Then there is the symbolic aspect. And I want to highlight the symbolic nature of rights. And this goes back to some of the comments that Professor Bakhti made yesterday. There's something so powerful about saying we are now equal and we are now free. Apartheid may have ended 18 years ago, and we know that Black people in South Africa are not free. They're still reeling from the effects of apartheid. Palestine is not free. Sri Lankan Tamils are not free. Indigenous people of Turtle Island are not free. The language of rights, whatever its downfalls are, gives us the bare minimum that we can fight for. It is a bare minimum, and it gives me and my allies as lawyers, as advocates, and as teachers teaching law students in one of Canada's 14 English law schools, something tangible to point to and say, look, there is something that is the bare minimum that we can ask for. And I think the final reason why I think that human rights are relevant is the following. We are currently experiencing a wave of populism. In the global south, you've experienced it for quite a bit, and people in the global north are experiencing it full on. If you turned on the news today, you would see what that looks like. So in this reality, rights are tools that we can deploy, which goes back to my point about the immediate needs of people of color. So in this age of populism, I don't think I can afford to give up rights. If I do, then I can't exist in this world. Thank you. That's stuck to my tongue.
Excellent. John.
Okay, thanks, Hala. And just to echo the thanks of my colleagues here to Mudar and Joyce and the translators and the volunteers and everyone who's allowed this to be happening. And I'm very happy to be here. So my paper isn't about human rights as such. It's trying to think instead about solidarity as an alternative idiom to human rights, and specifically about the idea of how horizontal solidarity between peoples as a form of social relations not managed or mediated by the state as distinct from the vertical paradigm of institutional rights that we often talk about. The Universal Declaration of Human Rights itself does potentially gesture towards this in part of Article 1, where it says that we as human beings are endowed with conscience and should act toward one another in a spirit of kinship or brotherhood, as the Declaration puts it. So one of the ways in recent history by which politically conscious people have sought to act in this spirit of brotherhood and sisterhood towards oppressed or besieged communities is through the formation of people's tribunals, which seek to fill certain vacuums left by formal international legal institutions and to provide what Richard Falk calls a jurisprudence of conscience. Okay, so the most well-known example of this, of course, is the Russell Tribunal on the Vietnam War that was convened by Bertrand Russell and Jean-Paul Sartre and others in 1967. Subsequent iterations of the Russell Tribunal were formed to look at abuses by right-wing dictatorships in Brazil and Chile in the 70s, on the rights of the natives of the Americas in 1980. The Permanent People's Tribunal also emerged out of this tradition and had its first session in 1979 on Western Sahara, its most recent last year on migrant and refugee peoples, and continues to work on these issues. There's been several other versions of this in recent years as well, including the Tokyo Women's Tribunal, the World Tribunal on Iraq, and the Kuala Lumpur Tribunal on Iraq, the People's International Climate Justice Tribunal, and so on. I was involved myself in the Russell Tribunal on Palestine project, which went from 2010 to 2014 as an advisor to the jury of that tribunal on international law. And so the idea for this paper really was to try and reflect on that experience of that tribunal as what it was trying to do as an attempted enactment of this spirit of internationalist solidarity, and on some of the virtues and the flaws that come out of the way it emulates legal form and process and the way it works. I had planned to write about this at the time. I never did. So this is my first attempt now at returning to it, and is a very initial sketch of some reflections and ideas. So just to caveat it with that, and I am very grateful for any perspectives at all that you might have on this. So I'll start with some thoughts about people's tribunals generally and how we might conceptualize the work that they do. And after that, I'll talk a bit more about the Russell Tribunal on Palestine itself. Okay, so people's tribunals open up alternative arenas of political legal contestation beyond the courts and professional institutions. They seek to offer a version of international law from below that disrupts the state centrism of international law. And the claim that they typically put forward is that they felt compelled to do so in response to official institutional power dynamics, right? So either to correct biases and or to fill silences. Their existence also, in a way, maybe challenges the assumption that what we think of as formal institutions or mechanisms, that they're always in some way legitimate, while informal ones are always illegitimate. But these types of tribunals are at the same time imbued with an intrinsic contradiction, right? That a people's tribunal is not a judicial institution, but it does replicate the image of law and legal procedure, right? So there is a jury, that jury hears evidence from witnesses, considers questions framed in the language of law, and issues a decision or a judgment of some description. The tribunal does so. Okay, so I have to speak slower. Sorry, Albert. So where was I? Sorry, the tribunal does so. It deals with these questions of law, hearing evidence, and so on. The tribunal does so, in one sense, to stake a claim to legitimacy by creating the impression of a formal legal proceeding. But at the same time, obviously, a people's tribunal is objectively not an officially constituted court of law with any jurisdiction to indict perpetrators or impose remedies, and it's explicitly conscious of that. And so when he was opening the Tribunal of Vietnam, Bertrand Russell said that our tribunal is not a group of disembodied formalists quibbling over definitions. We are not judges, we are witnesses. Our task is to make mankind bear witness to these terrible crimes and to unite humanity on the side of justice in Vietnam. Right, so that absence of a dispassionate judicial temperament is the basis for one of the common critiques of people's tribunals, which is that they carry the pretense of an impartial court but are not impartial. And that criticism, in a way, misses the whole point of their existence, which is more about publicity and solidarity than it is about impartiality over imperialism. And so Russell said that we investigate in order to expose, we document in order to indict, we arouse consciousness in order to create mass resistance. That is our purpose. The people's tribunals are also typically critiqued for lacking rule of law legalism's favorite fiction of balance. So a lot of people obviously would have criticized the Russell Tribunal and other versions of people's tribunals on this basis, that it's one-sided, double standards, etc. Even people on the left, for example, Stockton Lind, who was an American historian and anti-war activist, he refused to be involved in the Russell Tribunal because of its double standard in investigating US atrocities, but not the North Vietnamese resistance. Those that were involved in the tribunal, though, were clear on this point. Tariq Ali, who was one of the participants, said that to say that we were biased, that both sides committed crimes, to compare two powers so unequal in every way, one having total control of the air, bombing day in, day out, the other having nothing in the air, it's just a joke. Everyone was clear about this. We had no legal power, we had no legal standing, we were screaming. It was a scream of rage to the world. And so this freedom from the need to maintain an illusion of balance allows a people's tribunal as an informal or as an amateur institution to pursue different traditions of ethics and justice maybe than international law's formal institutions tend to do, and in some cases has allowed them to provincialize Western legal practices, to counter epistemic injustices and so on. Christine Chinkin, who was involved in the Tokyo Women's Tribunal, talks about the benefits of freedom from the constraints of formal judicial procedures, how this makes it a more human process for those affected to speak freely and to tell their stories. And Diane Otto has also written about about the politics of listening in women's tribunals she was involved in, and about the less predetermined versions of responsibility and justice that they offer or allow for. Okay, so there's a lot more we could say, and there's a lot more scholarship that's been coming out in recent years on people's tribunals generally, but I'll just leave it with that for now and move on to the Russell Tribunal on Palestine specifically, which was established by the Bertrand Russell Foundation in 2009, held 5 sessions between 2010 and 2013, which confronted some of the questions, at least, that professional legal institutions in the UN and elsewhere have tended to avoid, right? So things like the arms trade with Israel, the European Union's direct responsibility for Palestinian suffering, Israel's constitution as an apartheid regime, the role of capitalism and corporate profiteering in the military occupation, and so on, right? And it received some similar criticisms from people like Richard Goldstone and others, similar to those that the Vietnam Tribunal had received, which the members of the Russell Tribunal on Palestine rebutted with similarly short shrift to, as Russell and Sartre had done before them, and said, you know, we're not here to be to do the same thing that the UN institutions have been doing, and to pretend that there are two sides and we two equal sides and we address them equally. That's not what the project is about, right? So that was the original project. There was then an additional special session that was convened in 2014 after the assault on Gaza that year. And during that period, at the end of the summer of 2014, while many international organizations were slow to react to what was going on, the Russell Tribunal got everyone together very quickly, brought the witnesses that could come from Gaza, brought others by video link and so on, and held another series of sessions, which included but also went beyond the standard form of war crimes analysis that we'd had on previous versions of fact-finding missions on Gaza, and addressed questions also around the proliferation of racist discourse in Israeli public and political life in that summer of 2014, and questions coming out of that related to persecution and genocide. Okay, so the jury of the tribunal, in some or all of the sessions, was made up of the following members, who I'm kind of loosely grouping here along geographic lines. So there were the European and Western anti-colonialists who were there in kind of in the tradition of Russell and Sartre. People like Stefan Hessel, who was in the French Resistance and a concentration camp survivor in World War II, and subsequently a diplomat and a writer and so on. He was the chairperson of the Russell Tribunal in Palestine. Ken Loach, the filmmaker, Roger Waters, the musician, Richard Falk, the international lawyer, and a number of others, including a number of lawyers and judges. Right, so that's from the Western side of things. From the global South, you had people like Aminata Traore, who was the culture minister in Mali, involved in the World Social Forum. Vandana Shiva, environmental Indian activist, and people like Giselle Halimi, who was the Tunisian lawyer of Jewish origin who had chaired the original Russell Tribunal on Vietnam, and some of you probably know as Marwan Barghouti's lawyer. Number of others then from the global South. I'm not going to list everyone. A specific group then of South African anti-apartheid lawyers and activists, John Dugard, Yasmin Suka on the legal side, Ronnie Castrels, who was an active member of the ANC and a government minister post-apartheid. They were all on the jury. Desmond Tutu was involved as a friend of the tribunal, but wasn't sitting on the jury at the time. There were a number of African Americans then on the jury: Angela Davis, Cynthia McKinney, and Alice Walker, who had also been involved in the original Russell Tribunal on Vietnam with Stokely Carmichael and James Baldwin. So that tradition was continued. And then you had Dennis Banks, who was an Indigenous American activist, member of the Ojibwe Nation, involved in the occupation of Alcatraz and the Red Power movement, and a founder of the American Indian movement, right? And so I'm presenting them in these categories not simply for the sake of any kind of identity politics, but because my experience was that certain members of the tribunal played key roles at specific moments in shaping the tribunal's approach to particular contentious questions on the basis of their own standpoint and experiences. I won't have time to go into a lot of detail, but 3 examples of issues where there was a lot of discussion and divergence of opinion among the jury members were, firstly, the question of Palestinian resistance and political violence, secondly, the question of apartheid, and thirdly, the question of genocide. So I'll just say a little bit about each of them. So some members of the jury, particularly some of the lawyers, were concerned with these criticisms around bias and the need to address the culpability of both sides for the violence in Gaza particularly. And so this was a site of debate. But ultimately, after those on the jury who had experience of being on the receiving end of state and imperial violence, who had been involved in various forms of political and armed resistance themselves. After they made their interventions, the jury as a whole was convinced and agreed that the remit to investigate Israel for its atrocities did not need to be balanced by any false equivalent examination of Palestinian resistance. There were similar concerns then at the Cape Town session about describing Israel as an apartheid state with a segregationist legal regime, whether this was going too far. The South African members of the jury who had struggled against apartheid there, and the African Americans who'd been involved in US civil rights movements, were both key in the end to persuading those unsure that this was an appropriate and necessary determination. And it was fairly quickly resolved and unanimously resolved, and the tribunal went forward on the analysis and the findings which it made around the Israeli state regime as a whole and its integrated control over all elements of the Palestinian people being a regime of apartheid. And the interventions of people like Ronnie Castrol's in that were crucial. The question of genocide was probably the most difficult then. So the tribunal heard arguments about sociocide, politicide, cultural genocide, testimonies from Israel about the upswing in racist rhetoric and incitement in public and political life during the summer of 2014, testimonies from Gaza about the extent of the killing and the destruction that summer, as well as the longer term conditions of life there. And at the same time, it heard testimony from international lawyers about the very high threshold needed to establish liability for the crime of genocide. So the jury was then divided on how to address these issues. Some felt genocide should not be mentioned at all in the findings, as the criminal elements and specific intent had not been proven, whereas the Indigenous and African members spoke about the need to remember that whatever the Genocide Convention says, genocide is not a single act, it's also a long-term process, and we need to be conscious of that. So the compromise that sort of was a productive discussion around that, the compromise the jury reached in the end was to include warnings about the danger of incremental genocide potentially being perpetrated in Gaza if things were to continue, and that public incitement to genocide had been perpetrated in the context of the 2014 invasion, and that the world should be put on notice of both of those findings. Right, so that's some kind of initial brief, I suppose, reflections on what happened. An intervention like the Russell Tribunal in Palestine is obviously not without its limitations. It does at least hold some value, I think, in exposing and defying the structural imbalances in the colonizer-colonized relationship, and the way that the jury worked through these issues was really interesting. Obviously, it's not effective in the professional legal sense of being able to deliver a binding enforceable judgment. The very idea of this type of intervention does matter, though, I would say, as a disruption of official processes and narratives, as an intervention in the ongoing kind of legitimacy war playing out over Palestine, Israel, and as a bridge to activism happening outside of legal spaces. And so maybe just to finish with a couple examples of what those type of bridges are or can be. The tribunal's analysis of Israel as an apartheid regime feeds directly into a lot of solidarity activism that's happening around boycott and divestment campaigns, things like Israeli Apartheid Week. It also feeds into civil society interventions at the UN, citing Israel for apartheid, into the South African government downgrading diplomatic relations with Israel. All of these things are in the same mix. And I think, maybe one final example, the roles played by African Americans in the Russell Tribunal seems to be indicative of a rekindling and a deepening of solidarity in recent years between Black American communities and Palestinians. After her involvement with the tribunal, the next book that Angela Davis wrote was one connecting the freedom struggles and movements typified by Ferguson and Palestine. In 2015, you had the Black Lives Matter delegation that came to visit Palestine, and in 2016, they issued their Vision for Black Lives agenda, which included calls for US government divestment from military expenditure and aid to Israel, condemned Israeli actions as apartheid and genocide. And so all things that the Russell Tribunal had looked at. They took a lot of heat, obviously, for doing so, but they did stand firm on that. And so that we could say echoes the ethos of previous generations, including the Black Panther Party, which situated itself in solidarity with the Palestinians. One of the Black Panthers who was most influenced by the Palestinian liberation struggle was George Jackson. And some of you probably saw the exhibition about him and his interactions with Palestine. That was here a couple of years ago. The curator of that exhibition, Greg Thomas, talks about these kinds of relationships that come out of these kinds of processes as being something deeper even than solidarity, and he describes it as one of radical kinship, which I think gives us maybe something different, not necessarily better or worse, but something different from human rights. So I will leave it with that. Thank you.
Thank you all for your enlightening contributions and for sticking to time. ما عندنا وقت لكتير أسئلة فبس رح ناخد يعني عدد محدود.
ممتازة. We do not have a lot of time, so let's take a very limited number of comments or questions, if you may. 1, 2, 3, and Fatih and Samira, so 4 in total. 4 comments in total.
ناخد حاليا 4. We're going to take the first 4 questions.
سنأخذ فقط 4 أو نعم 4 أسئلة وبعدها إذا في وقت رح نأخذ كمان.
My question is for
سؤالي هو لأوشا. شكرا جزيلا.
So you've it might be a stretch, but do you think there's a link between shedding light on climate change crisis has to do with threatening the sovereignty of nation states, or forcing nation states to deal with climate change might threaten their sovereignty? Thank you so much.
It's not a question, it's a comment. I want to make reference to Dr. Natarajan's comment that the problematics of seeking justice through domestic colonial law, and to Dr. Xavier's comment as using international law as an instrument in defense of decency. Correct me if I'm wrong, but I believe that access into international law procedure requires that that the person appealing to international law first exhaust all domestic legal stages, which really means that you have to lose and lose and lose and lose and lose and lose and lose before you access. And in a way, that is absolutely necessary. So you turn to domestic colonial law in order to attack it, reverse the equation and attack it through the venue of international law. Colonial law is a criminal instrument and can be used in defense of decency. The same applies to international law as described by or referred to by Dr. Xavier. And I want to make a specific reference to another criminal instrument, and that is Israeli citizenship. Israeli citizenship is a settler colonial document. 20% of the citizens of Israel are Palestinian Arab citizens, and their patriotism is on part of any decent Palestinian that is, who is not a citizen of Israel. And that criminal document, which is available to 20% and is available to anti-Zionist citizens of Jewish extraction, can be used and should be used in order to, as an instrument in defense of the rights of this abused and colonized population. So the fact that a criminal instrument can be turned around in defense of human rights is definitely relevant to the question of Palestine. Thank you.
Thank you. فاتح لو سمحتي.
Thank you. And thank you all for your presentations. I had a short comment and a question. My short comment refers to John's discussion of the Russell tribunals and that process. And I thought that was a very good summary of the importance of projects like this. And I myself was part of the Permanent People's Tribunal on the former Yugoslavia in the 90s. And what I want to point out about that is, and I thought your characterization of the work was very good, that although it claims always to be a people's version of international law, of a view of law, of advocacy at the expense of the supposed impartiality of judicial systems, it still uses the language of law and the language of international law and the texts of international law and rights as they exist. So when they talk about genocide, the debates about genocide that you are talking about really had to go back to the definitions, the legal definitions of genocide in international law. So in that sense, the difference here is using the same texts of law, it's how you choose to use that law in a permanent tribunal setting that may be different from an international criminal court setting, for example. So, and I think that's an important thing to remember, that still the text of the law remains very important and crucial, because that will be the basis on which we can, discuss and change. And that leads to the second comment, which is really a question. International law is not static. It's not frozen in time. It doesn't get dropped at one point in time and remains forever. It is changing. It is constantly moving. International law in the 19th century is not the same as it is today. And it can still be changed. So if it is inadequate and if it's incorrect, then we change it. And I think the system of human rights law that we have now, that has been developing pretty consistently and regularly since 1948, and actually from before, if you go back to the Hague regulations of 1907 that had a number of human rights elements in there, then the question is, don't you think that changing nature of international law should affect how the determinations we have about the role of international law? In other words, we often make judgments on international law with this kind of subsumed understanding that it is what it is, but that still it can be changed, and there will be efforts to change it. And yes, states are responsible to change it. They are the ones that negotiate the text. But that's where then the popular movements and the solidarity movements and the Russell tribunals and all of us on the ground that are pushing for those changes can, over time, perhaps not in my lifetime, do affect those changes. So it's a long-term process, isn't it? Thank you.
This too is a question for John, and it follows up on Fatih's question, actually. I was one of the organizers for the World Tribunal on Iraq, the New York session at the time. I was a graduate student, and we was one of the organizers. And some of the debates were about actually the lawyers participating. So it was a process even before the jury came in. The process of translation to law happened with the kinds of arguments that we agreed that lawyers would stage at the time. And so my question to you, there is a process of translation to law, and I'd like to think about it as translation, right? Not as necessarily adopting illegal logic, but there's translation of political arguments to legal arguments. And I'm wondering, or there is a mediation between the two that happens. My question, and I don't know if you can answer it, but I'd be interested in thinking about a comparison between what happens in the tribunals in the 90s, 2000s, and so on and so forth, and the ones in the 60s. Because what strikes me about the 60s is that there was an ability to maintain parallel languages without necessarily always mediating them. Whereas the process of translation that happened, at least in the World Tribunal in Iraq, was truly to make the arguments legal, right? As Fatih was saying. And so I'm wondering about the fate of solidarity in these two different historical moments, whether there was this ability to maintain vocabulary that is not necessarily legalistic next to the legalistic one. And whether that disappears later in latter tribunals post-90s, whether it disappeared in the Russell tribunals. I'd say that in the World Tribunal on Iraq, the New York session at least, there were other tribunals elsewhere in the world. The legal language was pretty dominant, although there were, conflicts and debates and so on and so forth. And Aicha's recent book is precisely about that, as she participated with us in the organization of the World Tribunal. So, but the comparative bit, if you could, do you see a historical, it's the same tribunal, but do you see a historical shift, or is there no historical shift in the terms of translation? Thank you.
Go ahead and then, no? Okay. So, Usha and John.
Thank you. So I'll start with the first question. Is climate change perhaps a threat to the sovereignty of states? Thank you. So that, I guess, in some ways, perhaps because the nature of the problem is certainly transboundary in nature, and it cannot be contained, and we know that it's extremely unequal. So I think that it's not just climate change, it's that it's happening in conjunction with extreme inequality, both of which in a way together can threaten the sovereignty of the state, because we then are automatically drawn to seeing the way transnational capital works, and the way there is a transnational capitalist class that is responsible for both problems, and there's a transnational subaltern class and all of that. So in that sense, yes, it forces us to use concepts that go beyond the sovereign state. So yes, it does. But on the other hand, I would say that this does not necessarily have to be a good thing, because human rights kind of also did that when it came about. It kind of pushed against the sovereignty of the state by pointing to this universal construct. And in a way, the danger with the growth of environmental law, international environmental law, is that it could essentially go the same way as human rights, where you actually then look back to the time when your state was accountable to you with nostalgia, because now accountability to you is in a far off country, which is even harder to enforce, right? So it is very, very difficult to get my president in Cairo to react to my needs, but it's even harder when my needs can only be met by decisions that are being made in Washington. And so there is that move that can also happen with environmental law. So there's sort of it could be, but that doesn't always have to be a good thing, is what I'm trying to say. Yeah. Okay, so the justice in domestic courts, the exhaustion of domestic remedies. I was thinking when you were saying that yes, it's almost always there in every single area of international law, but I was thinking of that in context of what John was saying. Well, couldn't you use that then as a spectacle in the theater? And you see that in some of the inter-American cases, where by the time they go to the court in Costa Rica, they have exhausted domestic remedies and they know they're going to lose. And so they lose spectacularly to get as much attention as they can, so that by the time they go to another forum where they feel that perhaps justice is possible, they then look to... they play it as a theater because they don't see it as a forum for justice, and that's all it's going to be good for them. So I was thinking that that's some ways that I've seen the exhaustion of domestic remedies used, and then there are other cases where, so basically the opportunity to do things like this is actually slowly being shut off in various jurisdictions. In the United States with the closing of the Alien Torts Act ability to litigate, and in Canada similar moves, and I think there's still some possibility in the United Kingdom. So even doing the kind of things I talked about, because some of them have been successful avenues for successfully negotiating these requirements, are slowly being closed off in various jurisdictions. Yeah.
I guess I'll try to address 2 points. Sorry. I guess I'll try to address 2 points. The first is about the domestic remedies. There's a really famous case in Canada called Sandra Lovelace, and she took the Canadian government to court for the fact that her marriage to a non-Indigenous person basically excluded her from her Indigenous status. And that case has then kind of managed to enforce a lot of the civil and political rights and economic, social, and cultural rights that were enshrined in the covenants into the domestic context, and has shaped the way in which we think about those laws. So when people do get out of the domestic context and they succeed in the international space, it trickles down, and it does really affect the ways in which we think about rights. And the final piece, I guess, the final comment that I want to make is about Fatah's point about the constantly changing nature of laws or international laws. And so I guess I want to kind of go to the drafting of the Rome Statute and the Genocide Convention. Right. So, of course, we had a number of international criminal tribunals by that point. And during the drafting process, the Vatican said, no, you will not change the definition of genocide. And if you do, we're walking. And a lot of the participants at that table had no way of kind of counteracting what the Vatican wanted to do. And so the genocide definition that we have is the old genocide definition with the mens rea of, intention to destroy in whole or in part 4 groups. So the law, I agree with you, it takes a while to change, and sometimes solidarities may not work either, right? And so we kind of have to figure out other ways to deal with that.
Okay, thank you for the questions. Maybe just to pick up first on that one from Fatah, this idea that the critique of international law is based on international law as it is, as if it's some fixed, unchangeable thing. I mean, I think, yeah, to a certain extent that is the case, but certainly for the third world approaches to international law perspective, there is this transformative impulse to it that is very much conscious, that the law has and continues to change. And so it's about how to tactically and strategically engage in such a way that it is changed or transformed for the benefits of people traditionally who have been excluded. And so Raja Gopal writes about this, about the idea of international law from below and the way in which the campaigns and mobilizations and agendas of social movements in some cases have been able to affect progressive transformations of international law. The question, maybe a separate question in terms of this conference, is whether, where human rights fits into that, or whether, if we're talking about international law from below, the focus should be more so on things like environmental justice, economic justice, racial justice, rather than individualized human rights. But I take the point and would agree with you in that sense. The other question you had about using being kind of not exactly adhering to the role of a formal court, but still using the texts of international law. I mean, in my experience, I would say yes and no, in the sense that if we go back to the example that I mentioned, the debates around genocide, for example, certainly in the process I was involved in, it may have been different with Yugoslavia, but the testimonies to the tribunal and what the jury was weighing up in how they dealt with the question of genocide included submissions and testimonies from sociologists, from political theorists, talking about genocide or related ideas of sociocide and politicide, not in the terms at all of the Genocide Convention. And so that wasn't so there was a consciousness that there is other ways of thinking about genocide. There was a particularly strong reference or consciousness of histories of cultural genocide against Indigenous peoples that happens outside the terms and conditions, let's say, of the Genocide Convention, temporally and definitionally. So they were all in the mix, as obviously, as well as the definition under Article 2 of the Genocide Convention. And so they were trying to negotiate and mediate around these more social or non-legal conceptions of genocide and how they marry with the legalistic definition. And so, yeah, I would, I suppose, qualify it that way. And to me, that was part, at least, of the added value of what a tribunal like that can do. You know, how much that fully translated in the way that the findings were written and expressed, I'm not sure, but certainly in the process, it was an important part. And so that obviously connects then to your question, Samara. Thank you for that. And it is really, I suppose, the core question and thing that I'm trying to do, or would be trying to do, with this project. The role of the lawyers in the Palestine Tribunal. I mean, there were lawyers on the jury, some of whom were more legalistic in their approach and their thinking than others. Most of them, to be honest, weren't that legalistic, or didn't, I don't think, fully see themselves there with their lawyers' hats on only or exclusively, and they were very much, you know, open to and involved in these broader ways of thinking beyond the law. But obviously it is, you know, it is a question, and like you say, that idea of translation is one that happens not just in terms of the jury's discussion. It happens in, you know, terms of my role, or the people that are there as legal people to be involved in supporting the work of the jury. It happens in the decisions over who is invited to testify, what kind of expertise is reified in the submissions. And again, my experience was that it was very inclusive, but it did, and so it included a lot of more radical visions than lawyerly ones, but it also did include lawyers. And so your question, you know, about the historical comparisons, I think is, you know, that was something that I have been thinking about, and did the whole idea of thinking about the original Russell Tribunal in Vietnam and this in conjunction with each other was to really try and get to that question. So I would love to be able to do that. I'd love to talk to you more about it, but I don't know that I have a full answer yet. The way I would like to get deeper into how the process happened in the Vietnam Tribunal, in terms of the discussions there, for example, again, over genocide, whether when they were talking about genocide in Vietnam or Cambodia, what was their reference point, and to what extent was, you know, that a legal question or a different question. So yeah, I'd be happy to continue that conversation. I just saw the picture of Aicha's book launched there yesterday, and I'm really looking forward to reading that as well. But yeah, I think that's all I can say for now.
شكرا جزيلا للجميع. Thank you for all the panelists. هلا عندنا الغداء برا والجلسة.
We have lunchtime. We come back at 2:30 to attend the round table.